David, you ready?
I'm ready, thank you.
Good. Then good morning, ladies and gentlemen. It's 9:30. We can begin with our hearing in the case of Mr. Seda and others versus the Republic of Colombia. We received a consolidated list of participants. It's very long, so I would propose that we do not spend too much time on it, but I would invite lead counsel to introduce those who are physically present here today shortly. So, Mr. Mulu, would you please start?
See if this is working. Thank you, Mr. President, and good morning to you all. With me here today on behalf of claimants, I have my partner, Ms. Champion. We have Ms. Kaloun, Ms. Ankita Ritwik, Mr. Pedro Soto. Next to him is Mr. Angel Seda. We have our local counsel, Mr. Alejandro Mejia. I believe also Juan Pablo Ruiz is not in the room. Okay. We have Ms. Nika Madun, and next to her we have Mr. Pierre Amariglio. And at the back we have Mr. Ben Harris.
Thank you. And the other participants that are on the list are connected online. And could you confirm that the list is all that the list reflects all those who actually participate?
Yes, that is my understanding. I believe the only one that has not yet joined is Mr. Justin Enbody, and to confirm the other claimants have signed the confidentiality undertaking. We'll share that with you. And Mr. Enbody will be joining slightly late, given that he's on the West Coast.
Good. Thank you very much. Now we'll turn to the respondent.
Good morning, Mr. President, members of the tribunal. I'm Yas Bani Fatimi. I act here on behalf of the Republic of Colombia from Gea Bani Fatimi Shelbaya Disputes. To my left, you have my partner, Jimena Herrera Bernal, also from Gea Bani Fatimi Shelbaya Disputes. Next to Ms. Herrera Bernal, we have Mr. Giovanni Vega Barbosa from the Agencia Nacional de Defensa Jurídica del Estado, that's ANGE. Next to him, we have Ms. Pilar Alvarez from Gea Bani Fatimi Shelbaya Disputes. Then we have the director of ANGE, Mr. Camilo Gomez Alzate, here with us. And then we have Ms. Ana Maria Ordóñez, also from ANGE. And then we have Yael Ripko Berman from Gea Bani Fatimi Shelbaya Disputes.
Thank you. And the same question to you, the respondent. The other participants are connected and...
To my understanding, yes,
Okay.
they are or will be connected. Thank you.
Very good. Thank you. And as far as the non-disputing party, the U.S. is concerned, is there somebody in the room? Could you shortly give us your name, please?
You need to press the button.
You must press the button.
There we go. This is Alvaro Peralta with the United States.
Thank you. Thank you very much. All right. Now, there are a few pending procedural issues that need to be resolved. Our idea was to postpone a discussion on the pending issues to the end of today and to start with the oral argument, unless there is any point that you would make against this order, Mr. Mulu.
Not from claimants.
Mrs. Bani Fatimi.
Thank you, Mr. President. We have not been able to introduce any new documents into our opening statement, and it's already too late in any house, so we're happy to postpone that to the end of today, but we would ask the tribunal to make a decision fairly soon, because that will have an impact on the remainder of the case, since these were documents that we were hoping to rely on during this
Yes,
weekend and starting to...
if we understand correctly, documents that you would like to use in the cross-examination of Mr. Seda, or?
That may include, indeed.
Okay. Okay, we will get back to this in the afternoon.
Thank you.
Okay, so we will then invite the claimant. to deliver its opening, please.
Thank you very much, Mr. President and members of the Tribunal. It's an honor to be here on behalf of the claimants, representing them in this case. And what I hope to do for you over the next 3 hours, along with my colleagues, is to summarize, not go through in extensive detail. I'm just trying to see if the slides have been put up.
I believe they need to be projected.
Mr. Molu, can you bring the microphone closer to you?
Yes.
Thank you.
Can we put the slides up if you don't mind?
I'm not sure if we got them by email too, because I haven't been able to connect recently, but
they
are we
should
going to
have been
get a
sent.
version?
Yes.
Okay.
Oh,
So
and we
a
also have-
PDF by email is always
We
most
have
welcome.
hard copies as well, which should have been distributed if they've not, please.
Here they are right here. Here we
The
go.
requisite technical difficulties have begun. Hopefully we can resolve them quickly. It should have been sent.
It's been uploaded.
Okay. I think it was and it was uploaded to the Box platform about 30 minutes ago. Mr. Piriscano, would you like us to wait for you to access it? Okay. Is that better? Better? Okay. It's quite large.
It's horribly large. But how big is it, Mary? It's about 26 megabytes. Okay.
You have access? Okay, perfect. Mr. President, may I begin?
Yes.
Okay. Now that the technical difficulties have been resolved, I would now like to commence our opening statement. And what I hope to do, members of the Tribunal, over the next few hours is to take you, and my slides have disappeared and now I'm on the screen. Okay, let's keep it to the screen. Let's keep it to the slides. What I hope to do over the next few hours is to take you through the following issues along with my colleagues. First, I'll present a brief overview of the case. My partner, Ms. Champion, will provide factual background on the case. I'll come back to you on items 3, 4, and 5. My colleague, Ms. Kaloun, will address you on jurisdictional issues, and time permitting, I will briefly conclude. But let's start with what, just by way of background, what this case is about.
I'm sorry to
Please.
to intervene, but we still have not yet received the confidentiality undertaking of Mr. Amorgia. So we need that before we proceed.
Can you provide to ICSID? It's been provided to Respondents' Council. We'll provide it to ICSID now.
Okay, great. Sorry for that.
No
Please
problem. It's
proceed.
better to get them all the issues addressed before we dive in too deep. So on the screen here we have a picture of Mr. Angel Seda, who's obviously here in the room, and we'll hear a lot about Mr. Seda. Obviously, we'll hear from him directly, but that's because the U.S. investors, all of them, got behind him as the principal investor. And this case is unfortunately a sad story about Mr. Seda, who moved to Colombia about 15 years ago in the prime of his career to invest not just capital, but his time, his effort, his expertise, his energy, his capital, to help develop the Colombian real estate market, and in particular the hospitality industry. And he chose Colombia, as you'll hear shortly, because he believed in the country. He believed in the future of the country. He saw its potential, he saw its opportunity, and he immersed himself in Colombian culture and Colombian society and lived there for many years. His family is there, his friends are there, and all of his employees were there. And the first investment that he made was to establish the Royal Property Group, which you've heard about. And the Royal Property Group, their first major project was the Charlie Hotel. If you've been to Medellin, Colombia, there's a good chance you stayed at the Charlie Hotel because it's one of the top hotels in the city. Here's a picture of it. That's an actual picture of the hotel. I've stayed there myself. I've been to the roof deck that you see on the bottom left there, which has a beautiful view of all of Medellin, which is in a valley. It's a beautiful city. And in a few short years, he established the Charlie Hotel as one of the leading hotels and brands in Medellin and Colombia. It was met with not just domestic, but worldwide acclaim. In 2012, it was listed as one of the top 120 hotels in the world by Condé Nast, one of the top 120 new hotels of that year. The New York Times has featured the Charlie Hotel. Vogue Travel has featured Charlie Hotel. It is, by all measures, a huge success. It wasn't the only project. As early as 2009, before the Charlie was even fully built, Mr. Seda began on his next venture, the Luxe by the Charlie, which was a 59-acre property just outside of Medellin. It was a resort town on a beautiful lake, on Guatapé Lake. Again, these are actual pictures. These are not renderings. This is parts of the resort that was built. A beautiful resort, again, having been there. And it came to represent the brand that Mr. Seda was creating in Colombia. Several houses are complete. There's a restaurant on the lake that's operational. Unfortunately, the hotel is only about 70% done and has been in that state since about 2016. Then, of course, there's the Meritage project. Now, these are renderings of the Meritage project that you see in the picture here. It's just outside of Medellin. It's in between the airport and the main city. It's 56 hectares. That's a lot of land just outside of a major city. It's like a subdivision. It was meant to be over 20 apartment towers, several of which were under construction at the time of the seizure, approximately 20 commercial units, and over 90 houses. At the time of the seizure, there were over 500 people working on site. It was, the best way I can describe it is a subdivision of Medellin. And there were several other projects that were in the pipeline. Tierra Bamba, 450 Heights, Santa Fe. Again, these are renderings of those projects that were all being worked upon by the Royal Property Group. But all of this came to a surprising, shocking, and unfortunate halt on August 3rd, 2016, when one prosecutor, Ms. Ardila Polo, who you will hear from, that's Special Prosecutor 44, and you can see that the office issuing this order is just her. No court supervision, nothing. Her administrative decision to, on that day, deliver this certificate of real property seizure. She appeared on site, and on August 3rd, 2016, put the padlock on the door, told everybody to go home, and said, that's it. That's it. The decision of one person brought all of this to a grinding halt. And you'll hear from her this week. And this is pictures, actual pictures of the Meritage in its current state. Mid-construction, everyone sent home. And since 2016, everybody who drives from the airport to Medellin drives by this. For the last 6 years, everybody in the country, everybody in Medellin, has been witness to this unfortunate story. And it was widely publicized in all of the major newspapers in Colombia. It's gone beyond that. It's been in the Wall Street Journal. This is a story that has been widely, unfortunately, read about. Seizure of land where an exclusive project is being built in Medellin. The narco property is what it was called in Antioquia that entangles a model. Complaint uncovered, problems at the Meritage plot. Those were the headlines that Mr. Seda had to face the next day. And the nail in the coffin was January 25th, 2017, when the determination of claim was submitted to the court, and the Royal Realty Property Group was effectively dead as a going concern. You know, there are moments in one's life that you look back on and you say, you know, that was a turning point. That was a fork in the road in my life. Maybe you moved to a new city, maybe you got married, you had a child. And you look back on August 3rd, 2016, and you realize that that was a fork in the road in Mr. Seda's life. He may not have known it at the time, because I think at that time he thought it'll be a few weeks. You know, the courts will take care of this. I will get my property back. But that day fundamentally changed his life. And it's sad, because you see all of these people that were employed there. You see how it was contributing to the benefit of Colombia. And unfortunately, since that day, he's had to turn his full attention to this case, to trying to get it back, to try and revive his reputation. But unfortunately, to no avail. You'll hear from Mr. Seda, obviously, tomorrow. You won't hear from Mr. Lopez, who did submit testimony into the record. He was the Vice President of Construction. He had experience working with several renowned real estate developers in Colombia. And he was there on August 3rd when that certificate was delivered. You'll hear from Mr. Wilson Martinez, who has more than 20 years of practicing law. He served with the Attorney General. He was the lead author of the asset forfeiture law that is the subject of this dispute. You will not hear from Mr. Medellin, who was a former Minister of Justice. He's known to be the father of the asset forfeiture law in Colombia. He was the legal advisor to the Attorney General in the implementation of this asset forfeiture law. He was an ambassador to the United Kingdom, truly one of the leading lawyers and true experts on asset forfeiture law in Colombia. You'll hear from world-renowned real estate experts, JLL, Mr. Clay Dickinson, and Mr. Ruiz, who's focused specifically on the Colombian market. And you'll hear from our quantum experts, Mr. Santiago de la Piane and Ms. Daniela Bambachi, on the damage that has been suffered as a result of the measures that we'll discuss today. I'll return to you to address you on the breaches, but before I do, I'll turn the floor over to my partner, Ms. Champion, who'll take you through some of the background facts.
Good morning, Mr. President and the Tribunal. So I'm going to give you a little bit about the factual background of what happened here. You've heard about Mr. Seda's real estate development career. Well, in 2006, he decided to sell his successful real estate development company in Los Angeles and head to Latin America. He was in search of a new market. He wanted to find the perfect place to start a new real estate development firm and lifestyle brand. After checking out multiple countries, Costa Rica, Nicaragua, Panama, Mr. Seda thought he had found the perfect spot in Medellin. As he describes it here in his witness statement, the newfound peace in Colombia was generating new economic opportunities. The president of Colombia at the time, Álvaro Uribe, was prioritizing economic recovery. And that was evident in Medellin, which was attracting a growing array of multinational companies. It had good infrastructure and was replete with natural beauty. To Mr. Seda, it seemed like the perfect place to build lifestyle properties and a brand. Respondent tries to turn Mr. Seda's optimistic nature into a negative, but it is not. Contrary to respondent's cynical view that by choosing Medellin as the place to embark on this adventure, Mr. Seda somehow knew exactly what he was getting into. In fact, Mr. Seda fell in love with Colombia. He believed that he could help Medellin turn the page on a violent and tragic past. by attracting foreign investment, building beautiful buildings, hotels, and housing to support tourism, business travel, and Medellin's growing middle class. Mr. Seda set out to do this in a way that fully complied with the law and contributed to the community, even when people told him it would be easier to cheat. Indeed, Colombia's argument that Mr. Seda and the other claimants who invested in Colombia are somehow not entitled to the protections of international law because they assumed the risk by doing business in Colombia would deprive the trade protection agreement of all meaning. Mr. Seda was motivated to realize his vision, so in 2007, he created Royal Realty Property Group, a real estate development firm, and purchased office space. He obtained a foreign investor visa and set about identifying potential opportunities. At its peak, Royal Realty had over 50 employees, many of them Colombian. Moreover, the projects and hotels in its pipeline would have employed thousands in construction and once operational. As Mr. Malou already mentioned, the Meritage alone had 500 people working on site the day that it was seized. As Mr. Malou has also explained, the Charlie Hotel was his first project. Mr. Seda came up with the idea for the Charlie Hotel by studying the hospitality industry in Medellin and looking for gaps in the market. He identified Lleras Park, which was a trendy neighborhood with good nightlife, but no hotels. He found a suitable lot, hired a law firm to conduct a title study and check the OFAC list, and hired a fiduciary to administer the funds for the project as required by Colombian law.
Excuse
As
me,
you-
Ms. Champion,
Yes,
this is the court report. Could you slow down? We have interpretation.
yes.
Yeah, thank you
My
very
apologies.
much.
Thank you for reminding me. As you have already heard, the Charlie gained international acclaim, and its occupancy rates have remained well above industry averages since it opened its doors in January 2011. These pictures show the beautiful finished product. The Charlie employs over 100 people. Mr. Seda next conceived of a luxury resort and residential complex close to nature, but also close enough to Medellin to provide a weekend escape for people in the city. He found a 59-acre property in Guatapé on a large lake, 6,000 feet above sea level, and just 2 hours from Medellin. Capitalizing on the Charlie brand, Mr. Seda called it Luxe by the Charlie. It was planned to consist of 43 privately owned lodge-style cabins, 18 apartments, and 17 lots for custom-designed and built homes. All of this would be anchored by a luxury hotel with 116 rooms, wellness facilities, meeting and banquet spaces, an aquatic center, and a beach on the lake. Mr. Seda again ensured that all diligence was done on the property and hired a fiduciary to administer the funds for the project. The concept proved to be so attractive that the 17 residential lots sold out on the first weekend of marketing, and all of the lots, apartments, and first phase residential units were sold within a few months. Construction began in September of 2010 and was substantially advanced when the Meritage seizure happened. I'm going to show you some drone footage of the site. It's beautiful. I just want to note that I have visited, and I can tell you from personal experience how beautiful it is and how hard it is to see this vision cut short and unfinished. But this drone footage is actual, and we'll show you completed construction on the property. Do you know how to click? By this time, Royal Realty also had numerous additional projects in its pipeline. There was Tirabamba. This was a mixed-use development 7 minutes from Cartagena. On this project, Royal Realty had already entered into a promise to purchase agreement for the land. It had completed initial designs, and it had negotiated with the local indigenous community for their approval for the project, as well as with the municipality. Engineering and topography studies were complete. There was also Santa Fe de Antioquia. This was a waterfront development along the Cauca River, whose central feature was to be a blue lagoon. The land for this project had been purchased and paid for outright, and they had obtained approval in the entitlement process with the municipality. The urbanism design was complete, and the engineering and topography studies were also complete. There was also 450 Heights, another mixed-use development, substantially through the planning phases. Royal Realty had negotiated purchase of the land with the sellers. It had completed the initial designs, was halfway through the entitlement process, and they had also socialized and negotiated the project with the local municipality. Engineering and topography plans were complete. So as you can see, Royal Realty had a number of projects in its pipeline. It was a very ambitious and serious company, constantly working, constantly coming up with new ideas. Another project in the pipeline was, of course, the Meritage. Envisioned as a large, planned community with single-family homes, a luxury hotel with long-term stay suites for business travelers, residential apartments, and retail frontage. The Meritage was intended to take advantage of Medellin's beautiful surroundings, but also remain within commuting distance from the city. Mr. Medellin contacted a number of real estate brokers and started touring around Medellin looking for an appropriate piece of land. He looked at about a dozen properties before he found one that seemed perfect. It was a site between the airport and the city center. It was bucolic and underdeveloped. It had been used for cattle grazing for a number of years. There was one issue, though, which was a toll booth between the property and the center of Medellin. But Mr. Seda learned that there had been discussion of moving the toll booth that had been tangled up in bureaucracy. So by interfacing with the toll booth operator,
Sorry to interrupt.
No
you,
problem.
but did you say that Mr. Medellin contacted a number of real estate broker?
oh, Mr. Seda, yes, apologies, yeah.
Goes without saying, but once it's on the record, you.
No, I appreciate the correction. The toll booth, Mr. Seda interfaced with the toll booth operator and the municipality of Envigado and helped facilitate actually getting that toll booth moved, which was a hindrance to the development of the project that Mr. Seda managed to overcome. Royal Realty entered into a sales purchase agreement to purchase the property on November 1st, 2012. Mr. Seda then contacted Corporación Financiera Colombiana, known as Corfi Colombiana, to serve as the fiduciary for the project. Corfi Colombiana is one of the largest fiduciaries in Colombia. It operates under the Grupo Aval umbrella, which owns a number of banks, including Banco de Bogotá. Grupo Aval is the largest financial institution in Colombia. Newport, Mr. Seda's development company for the Meritage, hired Otero and Palacio, a very well-regarded local law firm, to conduct a title study and a study of the seller, La Palma, Argentina, including checking the names of prior owners and La Palma against the OFAC and UN lists. The title study and study of the seller identified no defect in title and no impediments to sale. As you can see, the company study states in the opinion section, favorable to alienate the real property identified with real property registration sheet number 001-930485. Corfi Colombiana, through its outside counsel, Francisco Cintura, himself a former Deputy Attorney General for Colombia, took yet another precaution. Mr. Cintura petitioned the Anti-Money Laundering and Asset Forfeiture Unit of the Attorney General's office, the same unit that later seized the property, to ensure that the property and its owners had no criminal associations. Corfi Colombiana's petition was extensive, 61 pages, and included the names of owners of the property going back nearly 60 years. Corfi Colombiana asked the head of the anti-money laundering and asset forfeiture unit at the time to check whether the property or any of its owners were the subject of an investigation. In compliance with its obligation to provide a truthful, pertinent, and timely answer to this petition request, the head of the unit, Danny Julian Quintana, confirmed that there was no record that any of these persons or entities or the property were the subject of an investigation. As you can see from the reports of claimants' legal experts in this case, Wilson Martinez, one of the designers and drafters of Colombia's asset forfeiture law, Corfi Colombiana went above and beyond by securing this certification from the Attorney General's office. All Corfi Colombiana was required to do was to confirm that the prior owners were not included on the UN Security Council list and use its government-approved SARLAF procedures for the seller, which there is no dispute that it did. Newport then set about creating the necessary contractual structures to execute the project and comply with Colombian law. As you can see from this chart, in this trust structure, as money comes in from the unit buyers, it is sent to the Administration and Payment Trust. This is kind of weird, huh? Whose documents require that the funds be used to pay construction and other necessary project expenses. As construction starts and money is drawn from the Administration and Payment Trust to complete the project, title passes from the seller of the land to the buyer, Newport, through the Parqueo Trust, phase by phase. No money is paid out of the Administration and Payment Trust until the point of equilibrium is reached. The point of equilibrium is reached when the developer has all necessary licenses, has sold enough units, or obtained enough financing to ensure the viability of the project. The ultimate goal here is to protect the unit buyers and investors. As Mr. Seda explains in his witness statement, because of Colombia's relatively underdeveloped long-term commercial financing markets, parties use these fiduciaries to mitigate risks and ensure that the assets and funds are used only for their intended purposes. Moreover, it is a requirement under Colombian law whenever you have more than 20 investors to use this type of fiduciary structure.
May I ask a question?
Sure.
Could you turn back to slide number 34? At the time of the visit on the site in August 2016, 17, which was the situation of the titles?
By the time of the seizure, I believe title to phases 1 and 6 had passed. I'm going to get to that actually. It's on a slide here. Oh, I'm going backwards, sorry. So you can see here the phases. This is the phase map of the project. Kind of starts with the retail, frontage, hotel, and condominium and works backwards. And so they had reached the point of equilibrium for phase 1, and phase 6 was associated with phase 1. So title to both passed to Newport at that time in this
So
deed
passed
361.
from Parqueo Trust to, if I follow the line here, the blue line, could you explain this to us? I see Parqueo Trust, it's slide 34.
Yes.
Then title to phase 1 and 6, and then this blue arrow, which goes to Administration and Payment Trust.
And then to Newport.
So you're saying in August 2016, title to phase 1 and 6 was with Newport?
Correct.
Okay. Please go ahead.
No problem. There was very strong demand for the Meritage units. The units sold very quickly. Monthly sales averaged 12 units a month at a pretty high price tag for Colombia, $440,000 back in 2013. These were the highest recorded monthly sales of any project in Antioquia at this time. We talked about the phase map already. As you can see, development kind of starts with the frontage and moves back. So on December 4th, 2015, the project reached a milestone by obtaining an urbanism license for all phases of the project. As Mr. Lopez Montoya explains in his witness statement, an urbanism license is granted only after the municipality approves the project, that it meets all requirements and is desirable for the community. It is more holistic and involves a very rigorous process. They had also obtained construction permits, and so at this point, construction begins in earnest. As you can see from this investor update in April of 2016, by mid-2016, construction was substantially advanced with foundations for 7 of the 8 towers complete, and structural construction for 5 of the towers was almost complete. Significant work had also been completed on the other structures. In addition, in May of 2016, Newport was approved for a loan of up to $11 million from Banco de Bogotá after passing the bank's own rigorous diligence process. The Meritage project was humming along on all cylinders in the summer of 2016 when things took a detour and the Meritage found itself seized on August 3rd, 2016. To understand the seizure, we need to take a step backwards. Just as Daniel Hernandez, a high-level prosecutor who will be testifying for Colombia in this proceeding, has had trouble pinning down a corruption case against Ms. Malagón and Ms. Ardila after years of investigation, some of the facts here remain elusive. But the coincidences in the timeline of the extortion scheme that Mr. Lopez Venegas engaged against Mr. Seda and events in the asset forfeiture case are remarkable. Specifically, a gentleman named Ivan Lopez Venegas first approached Mr. Seda in 2014, long after diligence had been completed and the contract to purchase the land was signed. Pre-sales for the project had started, and the project was gaining publicity as a runaway success. I think this is important because it's likely what drew Mr. Lopez Venegas' attention to Mr. Seda and the project. Mr. Lopez Venegas started leaving phone messages at Royal Realty, claiming to be the rightful owner of the property and demanding a payoff of $660,000 US, or he said he would go to the media. Unfortunately, as a real estate developer, Mr. Seda was accustomed to extortion demands. He asked his in-house counsel to take a look into the matter, and he noted that Mr. Lopez had never been a title holder for the property and that he appeared to be a drug trafficker. Mr. Seda reported the threats to the relevant stakeholders, including Corfi Colombiana, and countered Mr. Lopez Venegas' false statements to the media to control reputational risk to the project. He then moved on from what he viewed as a baseless extortion demand, confident in the diligence that had been done. As had been Mr. Seda's experience with other similar extortion demands, once Mr. Lopez Venegas realized that Mr. Seda was not going to pay him, he went away. But unbeknownst to Mr. Seda, around that time, Mr. Lopez Venegas filed a criminal complaint on July 3rd, 2014, before the Organized Crime Unit of the Attorney General's Office. So this thing is hard to control. Oh, really? There we go. There we go. I will figure this out. There we go. July 3rd is when Mr. Lopez Venegas files his complaint. The organized crime prosecutor who took the complaint referred it to the money laundering and asset forfeiture unit, where it was assigned to prosecutor number 37. Mr. Lopez Venegas' complaint tells a convoluted story about his son Sebastian Lopez Betancourt supposedly being kidnapped in 2004 when Mr. Lopez Venegas was in jail in Florida. And according to Mr. Lopez Venegas, his son is forced to sign over his interest in land in Colombia by being kidnapped by members of the Oficina de Envigado. Mr. Lopez Venegas did not tell the organized crime unit that when he filed the complaint, he was simultaneously trying to extort the developer of the project. In fact, he doesn't mention the Meritage or Mr. Seda at all. The kidnapping story has since been discredited, but given the timing, it seems likely that it was a convenient ruse to try to use a criminal investigation as leverage against the project. In other words, Mr. Lopez Venegas saw an opportunity to create trouble for the project and get paid off to go away. It seems that the Attorney General's office did not take Mr. Lopez Venegas' complaint in 2014 very seriously either. The organized crime prosecutor who took the complaint referred it to the money laundering and asset forfeiture unit, and the judicial police did some preliminary investigations. The criminal case remained quiet for nearly 2 years, and so did Mr. Lopez. But he resurfaced again in April 2016 with a new strategy. This time, Mr. Lopez Venegas had a lawyer, Victor Mosquera Marin, who contacted Mr. Seda on April 7th, 2016, claiming to have proof that Mr. Lopez continues to be the legitimate owner of the Meritage lot. Mr. Mosquera demanded that Mr. Seda meet with him in Washington, D.C. on May 2nd, quote, with the aim of exploring an alternative resolution to the dispute by means of direct negotiation. Mr. Mosquera made unspecified legal threats. He warned Mr. Seda that in case you are not present, or if there is no agreement regarding our aims, we are advising you that my principal is willing to begin the appropriate domestic or international legal actions. Meanwhile, back at the asset forfeiture unit, just a day after Mr. Mosquera's letter to Mr. Seda, on August 8th, 2016, the head of the unit, Ms. Andrea Malagón, suddenly assigns the Lopez Venegas case to prosecutor number 44, Alejandra Ardila Polo. Ms. Malagón disregarded that the case had already been assigned to another prosecutor for nearly 2 years. Once she was assigned to the case, Ms. Ardila moved quickly. From the moment she is assigned, she has in hand a memo from the judicial police dated April 8th, 2016, noting that there are 47 properties in Colombia associated with Mr. Lopez Venegas, but she immediately zeroes in on the Meritage property. In the meantime, Mr. Mosquera is persistent. He contacts Mr. Seda again on April 27th, demanding confirmation that Mr. Seda will attend this May 2nd meeting in Washington to reach a, quote, brokered solution. Otherwise, Mr. Mosquera threatens he will commence unspecified legal proceedings. Mr. Seda was understandably concerned about this threat of legal proceedings against the project. So he told Mr. Mosquera that he was willing to meet in Colombia, but Mr. Mosquera responded that it was too late. His client would pursue his legal proceedings. That turned out to be a tutela filed on May 6, 2016. In the tutela, Mr. Lopez sought a seizure of the property under the Colombian Criminal Code and sought to enjoin Royal Realty from proceeding with the project. The court denied that relief quickly, but instructed the organized crime unit to make a decision within 15 days whether to investigate or dismiss Mr. Lopez Venegas' criminal complaint. Mr. Seda was disturbed by the aggressive nature of the tutela. And Mr. Mosquera and Mr. Lopez Venegas did not simply disappear after they basically lost it. Far from it. They re-engaged with Mr. Seda in June, this time in a far more threatening manner. It is at these meetings in June of 2016, before Mr. Seda is even aware that there is an active asset forfeiture proceeding implicating the Meritage, that Mr. Mosquera tells Mr. Seda that he has connections in the asset forfeiture unit, and in particular with its director, Andrea Malagone, and prosecutor Ms. Ardila. Mr. Mosquera brags to Mr. Seda that he talks to Ms. Malagone on a weekly basis, and that she will seize the lot if he asks her to. They demand that Mr. Seda pay Mr. Lopez Venegas 19 million US dollars. You can see the escalating nature of the demands from $660,000 to 19 million. At that meeting, Mr. Lopez and his henchmen show Mr. Seda pictures of his children in an obviously threatening gesture. Mr. Seda flees the meeting, and I'm going to show you the text messages sent to him. Oh, I'm going backwards. By Mr. Valderrama as he flees the meeting. Mr. Valderrama sends him these conciliatory messages. Come back. Let's restart the conversation. Forgive me. I appreciate your presence and your position was made clear. I'll be available if you want to restart the conversation. But ominously, there are other signs that someone in the Attorney General's office may indeed be supporting Mr. Lopez Venegas' scheme. Shortly after meeting with Mr. Mosquera and Mr. Lopez Venegas in mid-June 2016, someone approaches Mr. Seda outside the Charlie Hotel. This person claims to be coming from the Attorney General's office and tells Mr. Seda to pay because the Attorney General's office is trying to help him. After 6 weeks of silence, Mr. Seda suddenly hears from Mr. Valderrama again on July 25th, 2016. Mr. Valderrama asks to speak urgently with Mr. Seda. Mr. Seda replies that he is not interested and that he will call the police. And that is these messages here. I'm not interested, thank you. If you contact me or threaten me, I will call the team that is already aware, both Army and National Police. Mr. Valderrama responds, Angel, warm greetings, understood, the negotiation chapter is closed. What was so urgent about Mr. Valderrama's entreaties on this particular date? Why did he reach out to Mr. Seda 6 weeks after the parties had last spoken, demanding a call? Well, if we go back to the timeline, we see that back at the asset forfeiture unit, just 3 days before that, on July 22nd, 2016, Ms. Ardila had signed the precautionary measures resolution to seize the Meritage property. Did Mr. Valderrama know this? It would explain the coincidence in timing and the urgency of his entreaties. Days later, on August 3rd, 2016, Ms. Ardila imposes precautionary measures on the Meritage lot, seizing the property and stopping all construction and development of the project. I will focus on the seizure in a moment, but needless to say, Mr. Seda was shocked that Mr. Lopez Venegas and Mr. Mosquera had made good on what seemed to be wild threats. And he was also shocked that the asset forfeiture unit would take such drastic action on the word of a drug dealer without even trying to discuss the issues of good faith and other key things with Newport or Corfe Colombiana. And ominously, just weeks after the seizure, once again, a man approaches Mr. Seda outside the Charlie Hotel and tells him that the Fiscalia advises Mr. Seda to do what is good for him and pay to keep the situation under control. Mr. Seda decides to report this scheme to U.S. authorities given the potential involvement of Colombian officials. So he arranged to meet with Mr. Mosquera, hoping to get evidence of the extortionate demand in writing. Mr. Mosquera had been careful about keeping specific monetary demands out of his correspondence. So Mr. Seda wanted to get evidence that there was a monetary demand here. So he meets with Mr. Mosqueda again in Bogota on October 27th, 2016. Mr. Mosqueda tells Mr. Seda again that if he pays $18 million to Mr. Lopez Venegas, Ms. Malagón and Ms. Ardila would declare Newport a good faith buyer and end the asset forfeiture proceeding. Colombia may try to argue that even if Mr. Mosqueda did say this, he was bluffing, that he didn't really have contacts or influence within the asset forfeiture unit. But there is every reason to think it was not entirely a bluff, because at another meeting with Mr. Mosqueda and Mr. Lopez Venegas just 2 days later, Mr. Mosqueda even told Mr. Seda that he could pay the money into a fiduciary account and only release it once the asset forfeiture proceeding had been lifted. Why would Mr. Mosquera propose such an arrangement if he was bluffing about being able to influence the asset forfeiture process? On November 9th, 2016, Mr. Mosquera put his cash demand in writing. Mr. Seda refused to pay it, and the asset forfeiture proceedings against the Meritage have continued to this day. These communications are all laid out in detail in these slides, which we include for your reference, but I will now turn to the seizure and its aftermath. There is Mr. Mosqueda's email with the cash demand. What's that? That's slide number 62. On the morning of August 3rd, 2016, Mr. Lopez Montoya, the Vice President of Construction for Royal Realty, was driving to Royal Realty's offices to go to work when he got a call from someone on site at the Meritage property. The person informed him that police trucks from the Technical Investigation Team, CTI, sort of the Colombian FBI, had shown up at the Meritage lot. The CTI agents were accompanied by prosecutors from the Fiscalia who were asserting that they had authority to seize the land. Mr. Lopez Montoya immediately drove to the site, and when he got out of the car, he was greeted by armed agents. There were multiple cars and agents walking around the property attempting to map it. A senior CTI agent told Mr. Lopez Montoya, "The prosecutors will arrive soon and will explain what is happening." He reassured him, saying, "Prosecutor Alejandra Ardila Polo is very nice. You should talk to her, and you'll see how quickly this situation can be resolved." Ms. Ardila entered the on-site sales office shortly thereafter and told Mr. Lopez Montoya that she was executing a seizure, that the government was taking over the lot, that all construction would have to cease immediately, and no further sales would be permitted. The team remained there for hours, mapping the property, posting signs, and Ms. Ardila Polo gave Mr. Lopez Montoya a certificate of seizure, signed by her. She told him she was implementing a resolution to seize the lot due to a complaint received, quote, a few months ago about a kidnapping of one of the former owners of the lot. Although she provided the certificate of seizure, she refused to provide Mr. Lopez Montoya with the resolution that was supposed to accompany it. She told him that Corfi Colombiana, as the fiduciary, would have to request a copy. She also rejected Mr. Lopez Montoya's attempts to show her evidence of the due diligence that had been done before the lot was acquired. As Mr. Malou has already alluded to, the impact on the project was obviously immediate. The seizure began reverberating through Royal Realty's entire business and portfolio like dominoes falling. The seizure was widely publicized, with the press grasping on to the most tawdry aspects of the story. The narco property in Antioquia that entangles a model. Seizure of land where an exclusive project is being built. As Mr. Seda sets forth in his statement, he immediately began receiving calls from contractors, investors, and unhappy unit buyers. The construction companies had to be told to stop work. Banco de Bogotá withdrew its financing and accelerated the loan. Unit buyers began to demand their money back. And the seizure also brought construction of Luxay to a halt. Colpatria withdrew its financing for Luxay. And as noted, the project remains in a state of half completion, with no one willing to finance a project that's associated with a company that's involved in an asset forfeiture case. These photos show the unfinished hotel, building materials that will probably now never be usable. Investors also withdrew their support. And as I said, the dominoes began to fall. Tirabamba, which was on the verge of commencing pre-sales, the sellers of the land said they could no longer work with Royal Realty because of the reputational risks, and they canceled the contract to purchase the land. Royal Realty also lost out on a lucrative hotel management contract. The sellers of the land for 450 Heights also pulled out of the deal due to reputational issues. And in Santa Fe de Antioquia, where sales were scheduled to start the following year, Royal Realty was no longer able to obtain any financing, and its investment partners were no longer willing to move forward due to reputational risk. In the meantime, Newport and Corfi Colombiana were doing everything they could to challenge the seizure. They knew that the asset forfeiture law was supposed to protect good faith third parties without fault. They knew that they had done substantial diligence on the property, even obtaining the certification from the very same unit of the Attorney General's office that did the seizure. As set forth in the expert report of Wilson Martinez, one of the drafters of the law, one of the objectives, even in the investigative stage of the asset forfeiture proceeding, is to determine if there are affected parties who are acting in good faith without fault. In particular, this analysis must be done before implementing precautionary measures because of the harm such third parties would suffer if they were wrongly imposed. But before Corfi Colombiana and Newport could challenge the imposition of the precautionary measures, they needed a copy of the resolution, which the Attorney General's office was wrongfully withholding. Francisco Cintura, who it was, as I've already noted, was Corfi Colombiana's outside counsel and a former vice fiscal, deputy attorney general himself, repeatedly went to and wrote the asset forfeiture unit to request a copy of the resolution. He was denied or ignored. When a prosecutor in the unit finally gave him a copy, she was referred for discipline by Ms. Malagone, though later exonerated. Corfi Colombiana immediately filed a petition for control of legality regarding the seizure. Corfi Colombiana pointed to the substantial evidence of diligence, the questionable credibility of Mr. Lopez Venegas' complaint, and the complete lack of analysis of good faith in the precautionary measures resolution. The court inexplicably rejected Corfi Colombiana's challenge, however, finding that this is not the venue to discuss whether Fiduciaria Corfi Colombiana actually is a third party in good faith without fault. But it was exactly the venue to do that. This chart provides a summary and overview of asset forfeiture procedures under Colombian law. In fact, Colombian law is supposed to protect third parties acting in good faith without fault at every stage of the process. It is one of the significant changes made to the law when it was revised in 2014. As you can see from this chart, it must be considered at every stage, and prosecutors can dismiss the proceeding at any time if they find evidence of a third party acting in good faith without fault who is affected by the asset seizure. Unfortunately, these safeguards failed here. On January 25th, 2017, Colombia proceeded with filing the determination of claim. Once this happened, it was clear that the asset seizure would likely remain in place for the foreseeable future and possibly permanently, completely depriving the project of all prospects of completion or value. In proceeding with the determination of claim, Colombia completely misapplied the standard of good faith, effectively determining that because there were alleged problems with land transfers, Corfi Colombiana must not have used appropriate means in its due diligence. This kind of retrospective analysis is simply not how the good faith standard works, as you will hear from our experts. Colombia also pivoted rationales for the proceeding. Rather than relying on Mr. Lopez Venegas's discredited kidnapping story, the determination of claim relies more on his criminal background and asserting that the lot was tainted and therefore subject to asset forfeiture, seemingly regardless of who held the land currently. And Colombia refused to consider Newport's rights at all. As you can see from this chart, this lays out some of the key dates and filings and decisions in the asset forfeiture proceeding. Notably, just about 10 days ago, the Superior Court in Bogota overturned the decision of the Specialized Asset Forfeiture Court, finding that Newport was not an affected party. That decision was overturned, and Newport has now been recognized as an affected party in the proceeding. So it's not entirely clear what's next. Newport will still have to, it will at least have the opportunity to prove its good faith. And that's just a little snippet from that decision. In the meantime, Colombia has listed the Meritage property for early sale. It has put it in the queue to be sold even before Newport has the opportunity to prove its good faith, nearly 6 years after the seizure. While assisting with the legal challenges to the imposition of precautionary measures and coping with the disintegration of his business, Mr. Seda was invited to a meeting with Daniel Hernandez, then a prosecutor with the Attorney General's Anti-Corruption Unit. Mr. Seda recounted the extortion scheme, a formal complaint, which Mr. Seda did on December 19th, 2016. Though Colombian authorities appear to recognize the falsity of Mr. Lopez Venegas's kidnapping claim, their investigation of it seemingly marches on, and Colombia now is even trying to somehow link. Again, corruption is hard to prove. I don't deny that. But it's not that there's no evidence here. It's that. With that, I will conclude the facts portion and turn this back over to my partner, Mr. Malou.
Members of the tribunal, I do want to go back to slide 84 for 1 second, which is an important decision. And this is a recent development, April 22nd, 2022. It's one of the new documents that's come into the record, so I wanted to draw the tribunal's attention to it. For a long time, Colombia has basically said Newport is not an affected party. And going to actually Mr. President's question, I think this is important. The court just decided that, in fact, Newport should have been identified as an affected party. Why? And this is at page 31 of the decision. Because of the original sales contract from November 1st, 2012. So as a result of that 2012 agreement, that purchase and sale agreement, Newport should have been recognized as an affected party. And an affected party under Law 1708, you'll hear about this week, they are entitled to have their good faith status assessed. So even the Colombian courts have finally agreed that this should have been done back at the outset. having, being an affected party.
May I have just a follow-up question? Even though that contract, the 2012 SPA contract, did not provide for transfer of title.
Correct. That did not provide for transfer of title, and I do want to just confirm one thing to your question. The status as of 2016 was that the trust held the title, and the beneficiary of the trust, just to clarify, was Newport. So what happens at that point? What actually happens for most of the units? They go directly from the trust to the unit buyer because there's been a contract entered into between Newport and the unit buyer. So it transfers usually from the trust directly to the unit buyer. If anything happens, the project doesn't get developed, there are any leftover units, then those units, Newport has the entitlement to have transfer of title to them. So even at the date of the actual seizure, they were the beneficiary of the trust, but title is still held by the fiduciary.
That is a correction to what was
Correct.
said
That is a
earlier
correction of
by
what was
Mrs.
said
Champion.
earlier. That is a correction of what was said earlier. But I think the critical point here is that the reason for it being an affected party, as decided by the courts, was indeed the 2012 original sale and purchase contract, because that's what gave rights to Newport in the property. It had certain irrevocable rights as of that point that gave it an entitlement to be considered as an affected party.
Just following up on the President's question, what is the use or the likely use of being recognized to be an affected party 6 years after the seizure, or almost 6 years after?
And it's precisely a question I intend to spend some time on. It's too late. Too little, too late. At this stage, the property is gone. That decision should have been taken by Ardila Polo. It was not reviewed by a court at the very outset, before she decided to take the property. She should have identified Newport at that stage as an affected party and assessed whether or not they were a good faith third party. And having assessed that, said, yes, they are a good faith third party, the seizure would never have happened. But we don't even need to answer that question. What would have happened if they made that assessment? Because that assessment was simply never made. And now it's done. It's gone. It's too late. Clearly, the Meritage project cannot be developed at this stage. So, it's very nice to have a piece of paper that says you should have been identified as an affected party, but obviously 6 years later, it doesn't do much good. So let's turn to the specific breaches. The first breach I want to talk about is that of national treatment. I'm not going to spend too much time on the actual articulation of the standards because this tribunal is obviously very well versed in investment treaty law. It's obviously in the deck for your reference. Article 10.3 is the national treatment provision, which entitles both the investors and the investments to treatment no less favorable than it accords in like circumstances to its own investors or investments, as the case may be. Interestingly, with respect to regional level of government, there's an additional provision that confirms that what we mean by this is you're entitled to the most favorable treatment accorded to investors or investments. So it's not okay to say, oh, well, one other Colombian had their asset also taken. You're entitled to the most favorable treatment that's accorded. And the standard for establishing a breach of national treatment is agreed between the parties. You must show that there was a foreign investor that has received treatment less favorable than other investors or investments in like circumstances, and that differential treatment is not justified. And as Colombia admits, the key question here that's in dispute is whether or not there are others in like circumstances, and to what extent can it or can it not be justified, that differential treatment. A couple of cases, just for your reference, to confirm that indeed the identification of those in like circumstances is a fact and context-specific exercise. It's Pope and Talbot and Occidental. Another case that's interesting and helpful in this regard is Archer Daniels versus Mexico. And I do want to spend a moment on Grand River versus the USA, which is CL 166 for the record, where what that tribunal said was that the relevant consideration is whether or not those in like circumstances, or to assess whether or not someone is in like circumstances, is whether or not they have been, the same legal regime applies to them. Are they subject to the same legal requirements? In this case, the asset forfeiture law. So I think that's a relevant consideration, whether or not others, and we'll talk about the comparators, they were subject to the same legal requirements. So who are the possible, in our submission, comparator groups that one should be looking at here? The first is the sister property with the common chain of ownership with the Meritage property. I'll talk about that in more detail. The second are other properties that are linked to Mr. Lopez Venegas. And the third are other persons with a current or prior interest in the Meritage property itself. So let me start with the first one, the sister property. So here is where Colombia says Mr. Ivan Lopez had an interest. Now, he was not on title. It was the entities that are named here. This was in 1994. Now, if that was their concern, you can see up here the red box and the blue box. This is the sister property, the bottom one is the blue box, and the red box is the Meritage. Back in 1994, they had common ownership. So if the Meritage property was infected because of that ownership, then so was the sister property. They also talk about Mr. Varela, the fruit seller. Again, that's a common history of the two titles. They also talk about the engineer here, Mr. Cardona. Again, common ownership to both the Meritage property and the sister property. And I'm going to go into this in a little bit more detail. What was the basis? And, you know, Colombia has flip-flopped, and even as recently as the rejoinder, they've changed what the basis was for this asset forfeiture. But if you look at the precautionary measures resolution, dated July 22nd, 2016, which was delivered, well, it wasn't delivered on August 3rd, but the basis for the August 3rd seizure, what does it say? It says the existence of reasonable grounds supporting precautionary measures is the real property recordation numbers 71999 and 72000. That's at this early stage. That's at this early stage. And it says it was acquired at that stage through punishable conduct such as kidnapping, threats, and personal misrepresentation, among others. That was the concern. This kidnapping story that we know is false, but was common to both lots. That was the only basis for the precautionary measures resolution. So if that was the basis for the precautionary measures resolution, why are they only taking the Meritage property and not the sister property? The sister property to this day is in the possession of the owners. Let's look at the determination of claim. There, they refer to the same Ivan Lopez transaction, alleged ownership that I just talked about, and then they talk about this next one, Mr. Varela. Again, as I mentioned, that's common ownership. That happened at a point in the history of title when these two parcels were owned, had common ownership. And then they talk about Mr. Cardona, the engineer. Again, common ownership. If they're concerned about the fact that these individuals, by the way, their concern was they didn't have enough money. How was Mr. Seda or Colombia Colombiana to know how much money they had to own or not own this property? Putting that aside, even assuming that that was a reasonable basis to say that this should have been taken, that ownership was common to both the Meritage and the sister property. But again, the sister property remains in the hands of its current owners. If we look at the Recorriamento, April 5th, 2017, what do they say at that point? At that point, they're back on Ivan Lopez. They're concerned again with this original transaction. And they're saying the origin of this investigation, the assets that are the subject of these forfeiture proceedings, arises from what? The illegal drug trafficking activities displayed by Ivan Lopez Venegas, who is alleged to have had an interest back in 1994. Again, his name was never on title, but even assuming that's true, why is there differential treatment between the Meritage property and the sister property? There is no reasonable explanation for this differential treatment.
Sorry to interrupt. So the point you're making is that since the seizure of August 2016 did not impact both properties,
Correct.
it cannot be that the seizure is compatible with Article 10.3 of the treaty.
Precisely.
That's what you're driving at.
That's precisely correct.
And to be compatible with it, the fruit seller Varela and the other fellow whose name Cardona should also have seen the adjacent property seized. Is that the point you're making?
No, it's slightly different, which is the investor here was entitled to no less favorable treatment than the other investors. So it's not that their property should also be taken, it's that if their property wasn't taken, then neither should this property have been taken. So it's not that they should be subject to the same bad treatment, it's that the investor here should be entitled to the same favorable treatment. So it should not have been taken from, the Meritage property should not have been seized.
Okay, but if the origin of the funds was polluted to begin with, for both Varela and Cardona, the consequence is that the same criminal seizure should have been applied.
Not necessarily, because remember, you have to do an assessment as to whether or not the purchaser was a good faith third party without fault.
They say it wasn't. They say they weren't in a way.
But they never did the assessment. And I'm going to come to this. They never even assessed it. To this day, they have not assessed it for Newport. So that may be what they're doing with the sister property, but they certainly did not assess the good faith status of Newport at all. In fact, it's only in April 2022 that they've even recognized that Newport was an affected party whose good faith should be assessed. That's been decided in the last 2 weeks. So there was differential treatment. That property, at the very least, the assessment of good faith should have been done if that's what's being done with the sister property. But nonetheless, there's no reasonable explanation as to why they did not. They seized the Meritage property and did not grant it the same treatment as its sister property, which was no seizure.
I have a more technical question on slide 106, just from my understanding, when you talk about sister property there, and then you refer to the number 001, minus 930481. Now, A4, is that lot A2? That was subdivided in 2006? I'm a bit lost here because you're talking about two lots.
Yeah, so
that
those
you
two
see
lots,
in the files?
it's
Lot A and Lot B.
Lot
but-
A and Lot B are
Yes.
011, that's 71999
Yes.
is Lot A.
Yes. Yes.
Lot B is 2000.
Yes.
Those are
And-
then reconsolidated.
Okay, and so what is sister property
The
then?
sister property, sorry, to be clear, is here. It's this blue box.
Okay, so it's
So-
basically Lot A2.
It's A2. So A is then split into A1, which ends up with the Meritage, and B also ends up with the Meritage, and A2, which is part of Lot A, ends up with the sister property. So correct. Lot A
Okay, I see now.
is
the-
split into two ultimately.
Yes.
Lot A2 is the sister property, correct.
Okay, and here I see the matricula then on slide 107 that corresponds to the one indicated on slide 100.
Precisely. That's 71999 and 72000. So 71999 was one of the, both Lot A and Lot B were both owned by these two entities that are alleged to be, Ivan Lopez had an interest at some point in time. Of course, that's not in any records that were public that anybody would know about, but that's the allegation that Colombia has made.
Okay.
But if that's true, then it equally affects both the Meritage and the sister property. They then later focus on the engineer. And this is in the rejoinder for the first time. This is not in any of the earlier documents. They're saying, well, we're now concerned with Mr. Santa Maria, who is, you may have read his name as Paraloca. And he was the real interest holder behind the engineer. How anybody would know this, by the way, is, I have no idea. But they've now figured out in 2021 that we think it's actually Mr. Santa Maria who had an interest. But even if that's true, his ownership interest is said to be at this stage when there was common ownership, again, of both the Meritage and the sister property. So at any point in time, whatever theory you pick of theirs, they're talking about individuals who owned this property as a consolidated whole before it was split between the sister property and the Meritage. Let's look at the second comparator group. They were concerned clearly with Mr. Ivan Lopez, right? They're saying, well, he was involved in drug trafficking. Well, if they were so concerned about Ivan Lopez, on April 8th, 2016, before the asset forfeiture, Miss Ardila Polo was sent a letter that made clear that Ivan Lopez had nationwide properties of 47. He had an interest in 47 properties, current or historical. There is not a single shred of evidence on the record that any of those properties have been subject to asset forfeiture. If they were concerned with the drug trafficking activities of Mr. Ivan Lopez, why haven't they gone after the properties of Mr. Ivan Lopez? It is inexplicable. If he was the object of this, if their public purpose, if their essential security concerns now that we've heard of, if their police power concerns is, we want to protect society against drug trafficking, go after the drug traffickers. And one of those, they say, well, we have limited prosecutorial powers or resources. And in fact, by the way, you'll see this, but Mr. Martinez, Dr. Martinez says, you have to focus on the proceeds of the crime. Right? And so that's whose assets you should have gone after. But if you look at Mr. Lopez Venegas, they say, well, this one was in development. So that's why we were so concerned about this one, because it was being sold to other people. Well, one of Mr. Lopez Venegas's, well, he was previously on title of the Quartier project, which is currently being sold, 67 apartments. And these are photographs of the construction as of September 10th, 2021. You can see apartments being sold. And guess what? If they're so concerned about development projects, well, why haven't they seized this project? What does Dr. Martinez say? He says the correct course of action would have been to attach the payment rights of the trustee and to identify who was a good faith buyer. So what could they have done? They could have said, well, we're going to seize the property of those who we know were bad actors. And before we seize the property of those who we're not sure, we're going to do an assessment of good faith. That's what the law requires, but was never done in this case. So the proper thing to do was to follow the chain of title historically, determine the illegality, seize their proceeds because they sold the property and made some money after it. So you can go after their property, other properties, bank accounts. It doesn't have to be the actual asset. You can go after their properties, other properties, ill-gotten gains, but you have not a good faith buyer. Clearly, this was differential treatment. I don't think I even need to show you cases, but bad intent or discriminatory intent is not necessary. Bill Kahn and Occidental make that clear. So even in Occidental, they say the tribunal is convinced that this has not been done with the intent of discriminating against foreign-owned companies, but that was the effect. That was the effect. And if that's the effect, there is a breach of the national treatment protection. And it cannot be reasonably justified. They say in their rejoinder, well, we have to prioritize our limited resources. Where should you focus your limited resources? on those who you know have conducted criminal misconduct, not on good faith third parties. But in addition to that, no additional resources were needed to make an inquiry of the sister property because it had the same history of title. So if they're concerned about limited resources, why it does not explain why they did not assess Newport's status as a good faith third party before seizing it. And they have not even proven at all that they did not have the resources to go after others. So it cannot be reasonably justified why there has been this differential treatment. In addition to differential treatment, there has been, I think, a very clear expropriation in this case. I noticed the time, Mr. Chairman, it's 11 o'clock. I'm not sure where exactly we're scheduled to have breaks, but since we've been going for about an hour and a half, I wonder if this is a convenient time before I get into expropriation.
I would think so, yes. So let's resume within 15 minutes, 11:20, please.
Thank you.
Thank you, Mr. President. I just have three very brief matters I didn't want to interrupt Mr. Moulou earlier. So first of all, I want to welcome Mr. Youssef Daoud, who is on Gaillard Bani Fatih Michel Baez dispute. He's writing at the end of the table. The second point, I didn't want to interrupt Mr. Moulou, but when the point was raised by ICSID about the confidentiality and the slides that mention confidential, it's true that we all have signed undertakings regarding confidentiality, but the point is that we need to actually raise it so that when we go back to the recording, we know what sections need to be removed and redacted, so that that is the exercise, and so it's a different exercise. I just wanted to highlight that. And then the last point, it may be very minor, but I have noticed for some time that there's a discrepancy of one slide between what we see on our screen and the binder that we have. So I wanted to raise that and see which version is the right version. Thank you.
We did remove a slide. I apologize. There is a discrepancy. So it looks, I think the hard copy is,
We'll have a incorrect number.
it'll be one ahead of the version that was shared
Yeah.
earlier.
Okay, thank you for these points. And Mr. Moulou, please proceed.
Thank you for raising that, Ms. Banafitemi. I appreciate it. And I will do my best to identify confidential information in advance. And if I do miss anything, we will make sure we let ICSID know for purposes of the revisions. Are we ready to recommence, Mr. President? So the next breach I'd like to discuss is the expropriation of claimant's investment. Again, I will not spend too much time on the standard itself. 10.7 of the TPA is the provision that deals with expropriation, and it expressly addresses both direct or indirect expropriations through measures equivalent to expropriation. And as in all investment treaties, expropriations are permitted, but they must meet 4 criteria. They must be done for a public purpose, in a non-discriminatory manner, on payment of prompt, adequate, and effective compensation, in accordance with both due process of law and Article 10.5, which requires, as we all know, fair and equitable treatment, among other things. The annex to the treaty provides some additional context, and it talks about specifically in the indirect expropriation context. Now, obviously here we think there has been a direct taking of the Meritage property itself, but the investment here is the shares in Newport, among other things. And so we have a situation of an indirect expropriation where an action, a series of actions by a party has an effect equivalent to a direct expropriation. They still own their shares, but they are worthless in our submission. And that's a fact-based inquiry that considers among other factors, and then it lists those factors, and I'll go through a few of those in a moment. What has been expropriated? What has been expropriated here in our submission is the Meritage claimant's interest in the Newport shares. Newport was the investment vehicle through which they owned their interest in the Meritage project. Newport was the one that entered into all of the various contracts and had economic rights as a result. And Mr. Seda is the 100% owner of Royal Realty's management company, which had a management contract for the Meritage project. And that contract is also obviously worthless. And so let's talk about the economic impact, which, as many cases show, is one of the key parameters for assessing whether or not an expropriation has occurred. And here I refer to Wiener Hotels and Zurich's that make it clear that if there has been substantial deprivation of one's property, that is not merely ephemeral, then that amounts to a taking. And I should mention, one of the things that Colombia says is, well, they might get it back. They might get this property back. But that doesn't matter for an assessment of expropriation. In the Wiener Hotels case, there was a hotel that was taken for under a year. And in that case, the tribunal found that that amounted to an expropriation. And as Zurich explains that no specific time set under international law for measures constituting a creeping expropriation to produce that effect. It will depend on the circumstances of each case. They refer to Wiener, which was less than 1 year. They refer to the Middle East cement case, where there was a suspension for 4 months. And then they compare that to S.D. Myers, where there was a limitation for only 3 months, which did not amount to an expropriation. In this case, though, whatever measure you use, 6 years has gone by, and clearly at this stage, it's not an ephemeral act. They have lost their property. And for many reasons, among other things, it's partially constructed, it's in complete disrepair. In fact, the government has listed it on an early sale list to actually be sold at some point. But no matter what, all of the unit buyers are out. They have sued the company. They're not coming back. The financial institutions are out. They're not coming back. The construction costs have obviously gone up. This project is done. Giving it back now is not going to fix that. As unfortunate as it is, not just for claimants, but for the country of Colombia. One of the factors that it's, again, not necessary to an assessment or finding of an expropriation, but it's one of the factors that one might want to consider, is whether there has been an effect on the reasonable investment-backed expectations of the claimants. And we would say, even though it's not necessary to a finding of expropriation, there has been an undermining of the reasonable investment-backed expectations, because Newport had acquired rights in the Meritage property through all of its contracts. It had obtained all of the necessary permits, the urbanization license, the construction license. It was, in fact, constructing on the property. So, of course, it had a reasonable expectation, and I'll come back to this later as well when I talk about FET breaches with respect to this property. The last factor to consider is the character of the government action. Now, Colombia itself has said it is undisputed that the asset forfeiture proceeding was a governmental action. So they accept that, but they're saying you have to look at the character of that action. And if you look at the character of that action, we would say, again, you would find that there should be an expropriation finding here. It was a taking of a property before any assessment of good faith third parties. That is the character of the action we're talking about. A taking without any hearing, a taking without, that was a complete shock to the claimants. And that character should be taken into consideration in making a finding of expropriation. In their counter memorial, at least, they said, well, it's excusable because it's an exercise of police powers. And Annex 10b talks about the fact, and you've seen this probably in other investment treaties, expect in rare circumstances non-discriminatory regulatory actions by a party that are designed and applied to protect legitimate public welfare objectives do not constitute indirect expropriations except in rare circumstances. Now, first of all, this is not a general regulatory action. This is not like the banning of a substance that's going to cause cancer. This is a specific exercise of discretionary authority by a prosecutor to take this property. So I would suggest that this is not a regulatory action. But in any event, I think it's important to recall that any public purpose is not an exercise of police power. And that's been confirmed in many decisions, such as Magyar versus Hungary and Pope and Talbot. And those cases have made clear that if you were to equate every public purpose to a police power, that would leave a gaping hole, a gaping loophole in international protections against expropriation. As we know, every expropriation to be lawful must be done for a public purpose, but that doesn't exempt the compensation requirement. That is one of the 4 criteria, in fact, for a lawful expropriation. So any public purpose does not equal the exercise of a police power. So what then rises to the level of a police power, something that's so significant that it exempts the compensation requirement under the expropriation provision? Well, the Magyar versus Hungary case is instructive. It says, first, the exemption from compensation may apply to measures of police powers that are aimed at enforcing existing regulations against the investor's own wrongdoing. So when the investor has committed a criminal act or has done something wrong, then that cannot be an expropriation that is worthy of compensation. And second, abating threats to the general public. So like I said, banning a substance that is carcinogenic, because we need to take this substance out of the general population circulation so that the general public doesn't get cancer, for example. That is the type of measure that amounts to a police power. This is not carte blanche to do whatever you want either, if there is that sort of public purpose. It's still, as the Baghat versus Egypt case explained, an action still must follow due process, and the measure must be proportional to the threat to public order. Here, there was no legitimate exercise of police power. Why? Because they were not going after the wrongdoing of the claimants. That first criteria in the Magyar case that I mentioned. How do I know that? Well, Colombia accepts that. They say at footnote 846 of their rejoinder, while it is true that the asset forfeiture proceedings were not initiated in connection with any wrongdoing of Mr. Seda, of which Mr. Seda was personally accused, they accept that these asset forfeiture proceedings were not some to remedy any wrongdoing of Mr. Seda. So this doesn't fall into that bucket. And it can't fall into the second bucket of trying to stop criminal activity. Why do I say that? Because they have not applied the asset forfeiture law in this case to any of the individuals or properties that are similarly situated of those individuals who they are saying are the criminals that are subject to the concern of the government. It's also not a legitimate exercise of police powers because it's disproportional to any alleged threat to the public. If the threat to the public is criminal activity, go investigate the criminals, take them off the streets, seize drugs if that's your concern. But failure to assess the good faith status of an individual before taking a property, how does that serve the public interest? In fact, it hurt Colombians. There are unit buyers who were also adversely affected. There were over 150 unit buyers who were also adversely affected. What we would submit is what should have been done is a focus on the disgorgement of the ill-gotten gains from the asset forfeiture proceeding against those who the government was concerned with, and that's not what they did. This seizure, without even taking the step to assess good faith, was clearly disproportionate to any concern. They took no criminals off the street. They did not stop in any way the drug trade in Colombia, but that's what they would like you to think. It was also not a legitimate exercise of police powers because it must be non-discriminatory, and for all the reasons I've already mentioned, it was not non-discriminatory. They did not treat the claimants in this case in the same way, and their investment in the same way as the sister property, which, by the way, one thing I failed to mention, that sister property, who is it owned by today? Mr. Lopez Venegas's sister-in-law. It's a member of Mr. Ivan Lopez's family. Other properties to Mr. Lopez Venegas. Other persons in the current or prior interest in Meritage property. None of them have been affected by the asset forfeiture proceeding. It should come as no surprise that I think this expropriation is unlawful. The tribunal needs only find that there was no compensation paid, which Colombia agrees, and I think it cannot be disputed. They say compensation is not due, but they accept that it was not paid. And as the ConocoPhillips versus Venezuela case explains, the failure to pay compensation in and of itself renders an expropriation unlawful. So to determine that this is an unlawful expropriation, that can end the analysis, but of course that's not, we can go through the rest of the criteria as well. It was a discriminatory measure, as you all know. It was not done for a public purpose in our submission. And here the Vesti case is helpful. It says the idea is to determine whether the measure had a reasonable nexus with the declared public purpose, was at least capable of furthering that purpose. And here, not even assessing Newport's actions, status as a good faith purchaser without fault before seizing the property cannot be seen to have a reasonable nexus to the public purpose. And of course, as I've said several times, the assets of those individuals who were actually involved in organized crime, alleged to have been involved in organized crime, their assets were not taken. No due process. And this is important. The ADC versus Hungary case explains what due process means in the context of expropriation. I'm going to come back to due process because it's an important concept in this case generally. They say an actual and substantive legal procedure for a foreign investor to raise its claims against the depriving actions is necessary before it's already happened. Before the depriving action, or shortly thereafter, you must have the opportunity, you must have reasonable advance notice, you must have a fair hearing, you must be able to plead your case before your property is taken. And that was not done here. There was no assessment of good faith status before or any point thereafter of Newport. There's also been a failure to accord due process because Colombia failed to follow its own law. And in the SIAG case and in Kubarax, the tribunals find that failure to follow your own law can amount to a failure of due process. And why do I say that here? Because Article 87 of Law 1708, and you're going to hear about this more later this week, clearly says so this is the article that deals with precautionary measures. And the very last sentence of that article that deals with precautionary measures, it says, in any case, the rights of third parties acting in good faith without fault must be safeguarded in taking precautionary measures. How do you do that? By assessing their good faith status before you take the precautionary measures. Otherwise, their rights are not safeguarded. We're 6 years later, they're now being said to be an affected party. How are their rights safeguarded if you don't actually assess their good faith status before you take their precautionary measures? And here again, I refer you to the decision of April 22nd, 2022, just a couple of weeks ago, where the court has concluded, this is from the decision, that the company Newport is entitled to participate in the case given that it has a pecuniary right with respect to the affected properties. So it is, quote unquote, an affected party because of that November 1st, 2012 agreement. That's that's Colombian law. That's the Colombian court telling us this now. I turn now to the breaches of fair and equitable treatment. Again, I will not spend too much time on the standard itself, only to direct you to Article 10.5, that each party shall accord to covered investments treatment in accordance with customary international law, including fair and equitable treatment. They make a big deal on that side, Colombia does, that this refers only to covered investments, that investors are not entitled to fair and equitable treatment, only investments are entitled to fair and equitable treatment. But if you look at Annex 10A, when they talk about what does customary international law mean for the purposes of Article 10.5, it says, with regard to Article 10.5, the customary international law minimum standard of treatment of aliens refers to all customary international law principles that protect the economic rights and interests of aliens, of investors. It's inseparable. The rights of the investor and the investment is inseparable, and the treaty itself recognizes that. In our submission, there is no distinction between the autonomous fair and equitable treatment standard and the minimum standard of treatment, and there are several cases that have made that point. Murphy versus Ecuador and Rosero versus Venezuela are just two of them. And in articulating what that standard is, another recent case against Colombia, Eco Oro versus Colombia, says that that standard includes non-arbitrariness, transparency, protection of legitimate expectations, the need to accord that investment and investors due process, not to act in a discriminatory manner. And they make clear, obviously, as this tribunal will know, there's no need to show bad faith. But even if there is a distinction between the minimum standard of treatment and the fair and equitable treatment standard, we would say this case satisfies that threshold, but nonetheless, we do invoke the MFN provision 10.4 of the trade agreement and refer you to the Colombia Swiss bit, which is at CL069, and specifically Article 4.2 of that agreement, to import, if it is a more favorable fair and equitable treatment standard, that standard does not equate the FET standard to customary international law. And cases like MTD versus Chile, which is at CL035 for the record, have done exactly that, import more favorable fair and equitable treatment standards of protection, where it was found that one treaty provided more favorable protection than another. So what are the breaches? Well, the first breach I don't need to spend too much time on, because you've heard me talk a lot about this, discriminatory treatment. And discriminatory treatment with respect to fair and equitable treatment requires two things: that similar cases are treated differently without reasonable justification. That's what is required. And for the reasons that I've already explained to you, and that I've put up on this slide 148 once again just for your reference, and so 149 in the hard copy, Colombia has not acted in a non-discriminatory manner here. And for the reasons I explained with respect to the national treatment argument, that differential treatment is without reasonable justification. But let me turn back to due process, because there are two and I'll go into a little bit more detail on these, important due process violations here that truly do even shock the conscious if one wants to go back to the near standard, which of course is not the standard here, but it would rise to that level in my submission. But there are two cases that I think are important to refer to in terms of this due process violation. Rumeli versus Kazakhstan, there the tribunal found that this due process requires one to have the opportunity to present their position before the action of the state. And there they found the decision was made without claimants having the real possibility to present their position. They were only verbally invited to a meeting 2 days before a meeting of the working group that then took an adverse decision. So there they were even given an opportunity. It was just 2 days before. Here, August 3rd, 2016 came as a complete surprise. No opportunity to present their position at all before the taking of this property. No opportunity whatsoever. Rumeli found a breach because they were only given an opportunity 2 days before. Here, there was no opportunity. And as this tribunal will know, that tribunal was presided over by Bernard Hanetio, and the wings were Stuart Boyd and Mark Lalonde. Similarly, in Deutsche Bank versus Sri Lanka, the tribunal there found Deutsche Bank was not informed of the case against it before the Monetary Board issued its stop payment order. It didn't know what the case against it was. It didn't have an opportunity to say, wait a minute, you shouldn't take this for X, Y, or Z reason. Just like in this case, Newport was not given an opportunity to say, wait a minute, before you take my property, I'm a good faith third party without fault. One needs not even to make that assessment. We'll explain to you that they were in fact good faith third parties, but that assessment was not even made, and they had the right to at least make their case, and they weren't given that opportunity, just like in Deutsche Bank versus Sri Lanka. And accordingly, there's been a breach of their due process rights and a breach of the fair and equitable treatment standard. There's also been a fair and equitable treatment violation because the actions of the Colombian government in this case were disproportionate, unreasonable, and arbitrary. I feel like after what I've just said, you don't even need me to make submissions on why the actions were unreasonable, disproportionate, or arbitrary. But there are other reasons why they are. The overriding principle of proportionality means that the administrative goal must be balanced against the true nature and effect of the conduct that's being censured, as the Occidental Tribunal put it. One must balance the administrative goal with the action that's being. As EDF versus Romena explains with respect to what is arbitrary conduct and excess of discretion, Ms. Ardila, for example, Ms. Ardila Polo taking an action, a discretionary action to do something, an excess of discretion is arbitrary. An action that is not based on legal standards, a violation of due process. These are all things that have been articulated as being breaches of that arbitrary standard. Now we submit that here the actions have been a violation of this standard. Why? Because as Dr. Martinez said, the correct course of action would have been to go after those who you know have engaged in bad conduct, in criminal conduct, and take their proceeds of crime, but not to go after a good faith buyer, or at least not to go and seize property before making that assessment of good faith status. So what is the disproportionate conduct in this regard? It's to take the property before even making that assessment. Why couldn't they have just made the assessment first? There was no urgency. They could have taken a few months and said, let's investigate this and see whether this is a good faith third party without fault. And if not, then maybe they can, take the property. But what was so urgent that they needed to take the property then? For the administrative goal that's being accomplished here, it was disproportionate. It was also arbitrary because it was based, the entire precautionary measures resolution was premised on what is known to be a lie. It was based on this kidnapping story. Now, what does Colombia say in its counter memorial? This is interesting. At 433, they say the asset forfeiture proceedings are not and were never based on the kidnapping story. That's what they say. That's the submissions in this arbitration. They were never based on this kidnapping story. But one only needs to look at the actual documents. For example, the precautionary measures resolution, where it says, the heading is the existence of reasonable grounds supporting precautionary measures. They're referring to the kidnapping. That was the basis. And they're saying until it can be ascertained that the statements that Mr. Lopez are likely true, what are we going to do? We're going to take the property. Until we can verify that it's not true, we're going to go ahead and take the property. Now, Colombia is running as far as they possibly can from this because they know that it's a false story. And they're saying it never was based on this. Well, I invite the tribunal just to read the documents. The decision by the asset, they're going to say, well, you know what, the courts ratified this. But the decision of control did not investigate the facts. That's important. The standard of review is very limited. So what we have a concern with is the actions of the prosecutor. The standard of review of the court was very limited. They did not investigate the facts. They assumed the kidnapping to be true. You can see that in the appellate decision on February 21st, 2017. They say, setting forth the details of the kidnapping of his son, which served as the basis for the building of this theory of the instant case. They expressly did not assess good faith status because they said it wasn't for them to do so. They said, it's not our job to do that. So the court has a very limited standard of review, but they're trying to rely on that review of legality proceeding as an imprimatur of, look, we did everything right. But you have to understand that those decisions in the context of the limited standard of review and what that court actually did and did not do. And by the way, that decision of the court, 21st February 2017. By November 21st, 2016, there's evidence in the record that everybody knew this was a false story. This is a letter from Michael Burdick from the US government to the National Police of Colombia saying that this kidnapping story was feigned. It was actually with his consent. During this purported kidnapping, he was actually seen out at a nightclub. This was all just a made-up story. And the government itself knows that it was a made-up story. Claudia Carrasquilla, the former director of the Organized Crime Unit at the Attorney General's office, in a public interview she refers to this attempt of theirs to portray themselves as victims of an alleged kidnapping that never occurred. That's what she's saying in public interviews. They knew that this is a false story. And that's why they're trying to run away from it. But that was the basis of the precautionary measures. This is arbitrary conduct because they did not follow their own law. As I mentioned, Article 87 of 1708 requires the protection of good faith parties without fault. And if you look at the burden of proof provision in Law 1708, that's Article 152, it clearly says, without prejudice to the foregoing, as a general rule, the Office of the Attorney General of Colombia has the burden to identify, locate, gather, and file the elements of proof which show the existence of some of the grounds set forth in the law for the declaration of forfeiture, and that the affected person, which as of April 22nd, 2022, the Colombian courts have said Newport is an affected person, is not a bona fide owner of rights without fault. The burden of proof is on who? On the Colombian government, and they never did this. They never did this. And as we know from this April 22nd decision, Newport is an affected person. That was the decision of the courts. You're going to hear from Dr. Martinez, who will explain. And Dr. Martinez wrote the law. He wrote the law. And he's saying before you engage in precautionary measures, before you invoke precautionary measures, you must assess whether or not there's a good faith party without fault, because that's the only way you can safeguard their interest. Otherwise, what happens? Here we are 6 years later in an arbitration, and good faith status has not been assessed yet. And what? What happens? How has their rights been safeguarded? Of course they have not been. You must do it before you seize the property. That is what Dr. Martinez has told you. And Dr. Medellin, the father of the asset forfeiture law, the former Minister of Justice, says the exact same thing in his report. He won't be here because they don't want to cross-examine him. So his testimony will go unchallenged, and this is what he says. In any case, the rights of third parties acting in good faith without fault must be safeguarded. He refers to that Article 7 and explains what that means. That means that they must first assess the good faith status of an affected party. And here I have the Ron Petrol decision, which is there just for your reference. And what this explains, and this is important because, they say all of this only affects the Meritage property. It doesn't affect the other properties. But what Ron Petrol explains is you have to look at the investment holistically. And the state must appreciate that the actions that they're taking might affect a broader set of an investment that is directly or indirectly in the line of fire. That's the language used in the Ron Patrol decision. The interests of TRG, they found, in that case, as such, stood directly or indirectly in the line of fire. And in that case, they found there was no evidence that steps were taken to avoid, minimize, mitigate that possibility of harm to this broader investment. And that's exactly what has happened in this case. Colombia knew or should have known that their actions affected all of these other investments that stood directly in the line of fire. Now, why do I say that? Because of the very nature of an asset forfeiture proceeding. The very nature of an asset forfeiture proceeding says one of two things. It says either that Newport itself was engaged in illegal activity, right? Someone reasonably would only have inferred that I must be concerned here because if they're taking something that this royal property, property group is involved in, I must be concerned doing business with them because they might have done something illegal. Otherwise, why was their property taken? Or it tells you that they did not conduct adequate diligence. But either way, the very nature of an asset forfeiture proceeding taints the Mr. Seda and the Royal Property Group. And that's clear from the evidence. Mr. Seda, as he testifies, could no longer borrow money. The asset forfeiture proceeding led to the cessation of all projects I was working on, in large part because funding dried up. He explains, my reputation as a property developer has been so adversely affected that I've been unable to secure additional funding for any other projects. Why else would he stop a hotel that's 70% done? Construction halted on the Luxay even though the hotel was 72.58% done. That's from the architects, the engineers, the contractor that was building the hotel. Mr. Lopez, who again, they don't want to cross-examine, and he's not here because he was the guy who was there on August 3rd. And that's what a lot of his testimony goes to. But he also talks about the fact that one of his calls with Colpatria, which was the lender to the Luxay project, formally said they stopped dispersing funds. They said, we will no longer formally approve any increases in the loan due to the ongoing asset forfeiture proceedings against the Meritage lots. That's uncontested testimony of Mr. Lopez. Other investors, Paladin, for example, said, we'll have to wait for this Meritage issue to be resolved before we invest further in Luxay. Tierra Bamba, they entered into a revocation of the purchase agreement because they had already entered into that agreement, so they had to revoke it, terminate it. And one of the reasons given are what? Given the difficulties and the scandal wheeled upon Meritage project in Medellin, which was disclosed both in written and oral media reports, a situation that may result in a lack of success in any other project that shall be undertaken in the future. That's August 3rd, 2017. The rationale given for the seller revoking and the purchaser revoking the Tierra Bamba purchase in the purchase agreement. They had the opportunity to manage another hotel in Tierra Bamba, and he gets a WhatsApp on September 13th, 2017 saying, yesterday, this is the owner of that other hotel. He says, yesterday at a meeting with our lawyers, we have determined that we must put an end to the negotiation process for the operation of our hotel since we don't want the situation that is occurring with the Meritage project to affect us in the near future. Now, Mr. Seda at this point, unfortunately, what does he say? He says, I'm actually surprised by this message, but I understand. I think that irrespective of the problems we're having, these are completely different and isolated, but I understand the concern because at this point, everybody's telling him this. He knows that he's just not going to be able to do any project anymore because nobody wants to do business with him. Santa Fe, as Mr. Seda testifies, since the imposition of precautionary measures, We have not been able to find a bank willing to finance the project. The partners with whom Royal Realty acquired the land advised us that they were not willing to move forward with the project. Land sellers with whom we were negotiating for 450 Heights advised us that they were not interested in continuing to move the deal forward due to the reputational issues that flowed from the seizure of Meritage. And one might ask, why are we here? What is the rationale for all of this? I was wondering, how did this come to be? You had a foreign investor come in, was providing jobs to Colombians, had established a well-regarded hotel in Medellin. These projects that are going to advance the economy of Medellin. What is the reason that one person, Miss Ardila Polo, can single-handedly bring this all to a halt? Why? What's the explanation? And there's no good explanation except for the one that Miss Champion took you to. There are a number of red flags that show you that the only rational explanation here is that there has been corruption. I'm not going to take you through this timeline again, but there are a number of indicia in this case that the only rational explanation is that they were trying to get some money out of Mr. Seda, and they thought he would pay to get the property back. Miss Ardila Polo could have lifted the precautionary measures if only the payment had been made. And what are the various coincidences and circumstantial evidence that shows you that this is in fact the actual thing that's happening here? Miss Malagon took over the investigation and handed Miss Ardila the case just 2 days after the Lopez reinitiated attempts to extort Mr. Seda. On April 7th, he was approached. On April 8th, it was reassigned to Miss Ardila. Miss Ardila arrived at the Meritage site and seized the project just days after the Mr. Valderrama threat that says the negotiation phase is over. Now they say, well, but look, she had actually signed the resolution on July 22nd. And so this July 25th intervention where Mr. Valderrama urgently contacts Mr. Seda is 3 days after. So she had already made the decision. But Mr. Seda didn't know that. But clearly Mr. Lopez did, Mr. Valderrama did, because why else would they be urgently reaching out? And he's saying, we need to urgently speak. And Mr. Seda rebuffs the attempt. He said, I'm not paying you anything. And Mr. Valderrama says the negotiation chapter is closed. And just a week later is when when the seizure, seizure certificate is delivered to the property. Mr. Mosquera repeatedly bragged to Mr. Seda about his connections and influence to Miss Ardila Polo and his connections with Miss Malagon. Mr. Seda was approached several times by individuals claiming to be representing, on behalf of Miss Ardila, saying, pay us, do the right thing, make these payments, and we'll make this case go away. Now, of course, there's no written record of that because we all know that's not the way these things are done. But that testimony is in the record in Mr. Seda's witness statement. An explanation, you don't need to make the finding, but we suggest that you could make the finding if you so wished. There has been corruption in this case, but given the number of other breaches, I can understand why there might be some hesitation to have to reach this particular finding. But there's more than enough evidence to do so should the tribunal wish. There has been a breach of legitimate expectations in this case. For the avoidance of doubt, I should say there's no need to reach that finding, assuming that the tribunal finds a breach, one of the other breaches, of course. Otherwise, this tribunal will have to confront the evidence of corruption and make a finding. Colombia frustrated investors' legitimate expectations. The concept of legitimate expectations, obviously, is well known to this tribunal. And when the conduct of a state creates reasonable expectations in an investor, it must abide by those reasonable expectations that they have created. And here, Colombia has frustrated the investors' legitimate expectations. Why do I say that? Well, Ms. Champion took you to the petition to the Attorney General's office, which was 61 pages, and this petition was to the very asset forfeiture unit that then seized the property, right? So they're writing to them before they buy the property, or sorry, it's after the sale and purchase agreement, but one of the conditions subsequent was sufficient due diligence is done. So that's one of the conditions in the sale and purchase agreement. And Corfi Colombiana says, prior to the transaction for this real property being finalized, you know, these conditions being satisfied, in which it might be interested with the exclusive purpose. What's the purpose of this petition? The purpose is of complying with the basic prevention measures as a precaution in order not to be utilized in asset laundering operation or the financing of terrorism. The company seeks to use high international standards of prevention and to avoid acquiring assets that may be involved in active investigations at the unit you direct. So they're writing to the unit and saying, in order to avoid, you know, being involved in a property that is subject to investigations, we are writing to you. Tell us, is anybody in the history of this title tainted? And they write back. And who is listed on this? It's important, I think, to know who's listed in this request. It's every single entity for the last 60 years that is actually on title. Every single entity actually on title. Plus, as of that date, every legal representative of the entity is listed on title. What they didn't do, and this is something that Colombia has said, is, oh, well, you didn't go back and look at who were the prior legal representatives. So you didn't go back and look in 1975, who was the legal representative of that particular entity at that point in time. That's one of the things that they accuse us of. But I don't think that can be considered to be the due diligence standard of any individual. In fact, this request in and of itself, as you will have seen from the testimony that you have read of the legal experts, goes well beyond what is necessary. Every single entity on the history of title, plus the legal representative as of that date, as of September 2013, was listed. And they write back, and what do they say? Having consulted the consolidated list, we can tell you no issues with any of these legal entities, no issues with any of their current legal representatives. And that's signed off on by Mr. Quintana Torres, the National Prosecutor Office Unit Chief of the National Anti-Money Laundering and Asset Forfeiture Unit. Now, if that doesn't create a reasonable expectation that there should be no issues with any of these legal entities on the history of title, then I don't know what does. They acted in good faith, relied upon this information, and in so doing, they were entitled to be treated as good faith purchasers without fault. But they were not. That assessment, as you know, has never even been made. And by taking the property, or even not, if they come up and say, oh, we looked at their good faith status. Well, if they looked at their good faith status, they had the entitlement. They were allowed to rely on this document, this representation by the state, that none of the entities that were actually on title were subject to any asset forfeiture or any concern by the unit at the time that they had acquired this asset. Since that date, since that type of certification that was obtained for this lot, guess what? The AGO, the Attorney General's Office, no longer issues those types of letters. What do they say now? This is a similar response to that type of letter that I showed you earlier, that type of petition. They now say, this was not in the letter that was obtained at the time, but they now say, this is one from 2020, It simply states that it is not possible to agree to provide information of any kind on the cited legal grounds. This does not constitute certification, nor is it an obstacle to an extinction process being brought forward in the future in the event that any of the causes of the extinction of ownership code coincide. The translation's poor, but you get the message. The message is they now say, they have this disclaimer. We're not telling you anything that you can rely upon in acquiring a property and to avoid extinction of domain at some later point in time. But that was not in the letter at the time to Mr. Cintura and Corfi Colombiana that the investors here also relied upon. I'll spend just a moment on the full protection and security standard. Now, there's some debate as to whether or not the full protection, as there always is in every case that I talk about the full protection and security standard, as to whether or not it's just about physical security or also legal security. And we would suggest that even if this treaty only protects against physical security, we rely upon the MFN provision to import the more favorable full protection and security provision to the extent it is more favorable in the Colombia-Spain bit, and that's at CL 053, and Article 2.3 of that bit is in our submission. It does not contain this language that Colombia relies upon, which is at 10.52b, where it explains the full protection and security requires each party to provide the level of police protection required. They say that addition of the word police is limiting. Our submission is that it's not, but even if it is, we rely on the more favorable provision in the Colombia-Spain bit. And the AMT versus Zaire award makes clear that this refers to the full enjoyment of protection and security of the investment. And among other things, a party should not be able to be permitted to invoke its own legislation to detract from such obligation. And what does it mean? The requirement is that it must show that it has taken all measure of precaution to protect against the investments of AMT on its territory, and similarly here of the claimants. And National Grid versus Argentina, just one example of a case where it explains that the standard is not limited to physical security. Professor Schroyer similarly explains that the measures necessary to protect investment against adverse actions of the state and private persons are covered, but here, of course, we're dealing primarily with the actions of the state. Those are the reasons why we say there's been a breach of the treaty in this case. I would like to turn now briefly to the essential security defense, and I won't spend too much time on this because it's just been briefed, and I assume the tribunal has read the pleadings. But I will address just very briefly the provision which says nothing in this agreement shall be construed to preclude a party from applying measures that it considers necessary for the protection of its own essential security interests. Preclude is defined in the Oxford English Dictionary as to make impossible, to prevent, to make something impossible. Now, clearly here, all this, it doesn't say the tribunal has no jurisdiction to assess whether or not there has been a breach or anything like that. All it's saying is that if invoked, it does not preclude a party from applying a measure. It's not saying it's a get out of jail free card. It's not a gaping loophole in the treaty. It does not exclude from the state from the compensation obligation. It does not exclude the state from the compensation obligation. It merely says that if invoked, they can continue their measure. And that's precisely what was found in the Eco-Ora decision in interpreting similar language, which I'll get to in a moment. So what does that mean as a practical matter? As a practical matter, that means, and by the way, this applies equally to the investment context and the trade context, which is relevant because in the trade context, as this tribunal will know, in the interstate trade context, the remedy is often what? Withdrawal of the measure, right? So if you apply a measure, a tariff, for example, that is unlawful, the remedy is generally withdraw the measure. And so what this is saying is that can't be the remedy. You can't order the state to withdraw the measure. If they invoke the essential security provision, they're entitled to maintain that measure. And all that's permitted then is, in our submission, a compensation obligation. Similarly, in the investment context, in 10.26 of the TPA, the treaty specifically allows the remedy of monetary damages or restitution. Now, we accept that if the essential security provision is properly invoked, and we don't think it has been, but if it has been properly invoked, then this tribunal is not entitled to order that second prong, restitution of property, because they are entitled to maintain and apply their measure. It does not say anything about jurisdiction, exception to liability, or anything like that. And they could have done that as they did elsewhere in the treaty. For example, Article 1018.1 provides no claim may be submitted to arbitration under the section if more than 3 years have elapsed from the date on which the claimant first acquired or should have acquired knowledge of the breach. That says you can't arbitrate the matter. There's no jurisdiction. Similarly, 10E provides that the claimant may not submit to arbitration a claim until after 1 year of certain events having arisen. There are express carve-outs for liability. For example, Article 10.4, footnote 2, says that the MFN provision does not encompass dispute resolution mechanisms. That's an express carve-out of the MFN protection to certain aspects that an investor might otherwise be entitled to rely upon it for. Article 10.75 notes that the expropriation provision does not apply to the issuance of compulsory licenses granted in relation to intellectual property rights. Those are carve-outs for liability, or jurisdiction. That's not what this provision was. They knew how to do that if they wanted to do that. But that's not what they did in this case. And to interpret the treaty in that way, to have this gaping loophole, give them a get out of jail free card, would undermine, obviously, the investment treaty chapter as a whole. It would make it ineffective, but it would also undermine the purpose of the treaty, which in its preamble clearly provides that the intention is to create predictable legal and commercial framework for the business and investment. By creating this gaping loophole, it would avoid certainty, avoid predictability. If at the time of a dispute, the state could pull out of this get out of jail free card and say, oh, we're out for any reason, from liability altogether. But that's not what the provision does. And in the Eco Oro decision, that's precisely what the tribunal found. They said, Colombia also provides no justification as to why it is necessary for the protection of the environment in that case not to offer compensation to an investor for a loss suffered as a result of the measures taken. And in 837, they explain, accordingly, the tribunal does not find that 22013 operates to exclude Colombia's liability to pay compensation to Eco Oro for its damages suffered. And there, the question was, what does it mean to prevent a party from adopting or enforcing measures necessary? Now, they'll say, well, it wasn't self-judging. But that's not the question here. The question here is, what does it mean to prevent a party from adopting measures to enforce the measures necessary? And requiring them to pay compensation does not prevent a party from adopting or enforcing the measures necessary, or in this case, applying measures. Requiring them to pay compensation, as the Eco Oro tribunal found, does not prevent a party from taking those actions. They can still take those actions even if they are required to pay compensation. It does not make it impossible, as the Oxford English Dictionary interprets that word, preclude for them to be able to take those actions. In any event, the new defense is time barred. We understand that in procedural order number 9, the tribunal has, for purposes of admitting this defense as a jurisdictional objection, allowed it. But for the reasons I've explained, it is not a jurisdictional objection. And you'll see that the language in the letter that Colombia subsequently submitted, they've shifted their language slightly from jurisdiction to justiciability. And that's an important shift, because I think they recognize that it's not a jurisdictional objection. And it is time barred because when it's not a jurisdictional objection and it's an affirmative defense, they had to raise it in their counter memorial and they did not. That's procedural order number 1 and Rule 26. Unless there's been some sort of extenuating circumstance or new facts, which there has not been. 2. The reason why that falls flat on its face is because the time at which that essential security interest had to be identified was at the time the measures were taken. Article 22.2 makes clear the essential security interest it precludes a party from applying measures that it considers necessary. So, let me explain. Nothing in this agreement shall be construed to preclude a party from applying measures that it considers necessary to protect itself against its essential security interest. So, of course, the essential security interest must have been known at the time that the measure was being applied, right? And that's exactly what the Nicaragua versus U.S. case said at the ICJ case, where they said if you look at the chronological sequence of events in that case, the activities of the United States, if they're to be covered by Article 21 of the treaty, they must have been at the time they were taken measures necessary to protect its essential security interests. But new facts that come to light now, in 2017, in 2018, in 2021, 2022, could not possibly have been facts or circumstances that gave rise to an essential security at the time they took their measure. It is impossible for a state to consider a course of action to be necessary to protect their essential security interest if they haven't yet identified that interest. And the fact that they did not raise this defense in the counter memorial is all you need to show that clearly, if they knew that this measures were taken for an essential security interest at the time back in 2016, then they would have been able to identify it in their counter memorial. But this is all just made up for this arbitration. And therefore, it's not a good faith defense. And there's a two-stage inquiry here. One, that the definition of essential security is made in good faith. The definition of the security interest in and of itself. And second of all, whether it's plausibly connected to a properly identified interest. And it hasn't been. The articulation of the defense has not been made in good faith because it's exactly the same purpose that they relied on in their counter memorial. The purpose they identified for their measures in their counter memorial was to fight organized crime, to attack organized crime. That's what they said at paragraph 303. And it's the same reason that they're articulating in the rejoinder. This is just a recasting of the very same purpose. So they have not articulated the defense, the essential security interest in good faith for purposes of this arbitration. And it is not rationally connected to the measures to the purpose, even if it was an essential security interest properly articulated. Why do I say that? Because the asset forfeiture proceedings have not even touched the assets or disgorged the assets of the crime members that they've actually identified. They can still look into those individuals. They can take their property. They didn't need to take this property. And more than anything, they accept that claimants have not done anything wrong. They say that in their submissions. Claimants accept claimants' wrongdoings is not the subject of these measures. If that's the case, then how could their essential security interest be advanced by taking these measures against individuals who they admit have done no wrongdoing? And finally, even if this essential security interest was properly invoked and could be invoked and did apply, other treaties that Colombia has entered into does not contain this essential security interest, and the investors here are entitled to equal treatment. If, for example, a Swiss investor had brought this case, there would have been no essential security defense because the Swiss Colombia bit at CL069 does not contain this affirmative defense. And substantive standards of protection, as we all know, MFN provisions do allow an investor to import more favorable investor protections when it comes to substantive standards. And as a very last resort, I don't think this tribunal even needs to get there. But if they do, the Colombia Swiss bit allows the claimants that equal protection. I turn now to the compensation that is owed to the claimants. It's necessary to prove causation. We accept that. The actions, obviously, the damage, must be by reason of or arising out of the breach at issue here. And if it can be proven that the normal cause of events, a certain cause will produce a certain effect, it can safely be assumed that a rebuttable presumption of causality between both events exists, and that the first is the proximate cause of the other. And I've taken you through a lot of this already, so I'll just highlight it and summarize it here. That Colombia's invocation of precautionary measures and asset forfeiture proceedings against the Meritage property halted development of the Meritage project, obviously. It caused banks to pull financing from the Luxe, and you've got citations on the slide here for your reference. It caused prospective investors to withdraw from Luxe. It precluded Royal Realty from securing financing for its other projects, and it caused business partners to pull out of those other projects. All of that evidence I've already taken you through. And they say, but wait a minute, the Charlie Hotel is still operating, but the Charlie Hotel is self-sustaining. It doesn't require any additional funding at this point. And so to point to the Charlie Hotel is still operating does nothing to explain how or why Mr. Seda would have been able to still operate all of these other projects. Obviously, he could not, because he needed funding. He needed business partners who were just not willing to do business with him anymore. I've already explained how their focus on investment specifically with respect to the FET and national treatment provision makes no sense, so I won't belabor that point. But I will spend a moment on the actual quantification of damages. I know you're going to hear from the quantum experts themselves later this week. I'm sure you're much more interested in hearing all of this from them than from me, so I will just do a brief summary of the key points that the tribunal will hear about later this week. The tribunal will be well aware that, and everybody accepts that fair market value captures the full reparation owed to the investors. And there are three ways to assess fair market value: the income-based approach, the market-based approach, and asset-based approach. And generally speaking, the income approach is the place to start. And Rapinski and Williams say that in their seminal text on the matter. And the reason is because you can modulate the drivers. You know the drivers that are resulting in the ultimate damages figure that you are going to determine. And so it's much better to be able to assess those drivers on an individual standalone basis. And you can do that through the income approach. But by using the actual expenditures that have been expended, despite what they say, and this is from Rapinski and Williams again, does not actually calculate the fair market value of an investment. This tribunal will well be aware of that. If I bought a car in 2018, what I paid for that car does not reflect what it was worth in 2019. Usually when I drive the car off the lot, it loses its value the very next day. Because of the pandemic, in fact, a year later, guess what? Used cars were worth more than what you paid for them a year later. 30 years later, it might be an antique and worth even more. But at the end of the day, what you paid for something does not at all tell you anything about what it's worth on a particular date of valuation. But more than that, it fails altogether to assess some cost approach. The actual expenses incurred does not take into consideration the know-how and the expertise, which is so critical to an investment, especially in this case. The market knowledge, consumer insights, vendor relationship, all of the things that Mr. Seda and the investors brought to this project was so much more than a piece of land. And none of that is valued when you take a sunk costs approach. The brand value, the track record of successful projects, it is more than just a piece of land. It is all of these things that come together that help you assess what is something worth, what is a business worth, what is a project worth. it is worth a combination of all of those things that is simply not captured by looking at what was spent. And Colombia appears to accept, by the way, that the DCF valuation is possible if you use the correct assumptions. This is at note 1,377 of their rejoinder. They say it is possible to correct some of the assumptions made by BRG to reach a more reasonable DCF value, which can be verified by appropriate cross checks, as demonstrated by Dr. Hearn. So Colombia seems to acknowledge if you use the right assumptions, a DCF can be used. But the ultimate question for this tribunal is it sufficiently certain that profits would have been made? And if yes, do we give you a reasonable basis to assess what those profits are? And to the first point, we think it is sufficiently certain that profits would have been made based on the track record of the claimants. If you look at the Charlie Hotel, everybody accepts, including respondents, that there were market-exceeding profit margins at the Charlie Hotel. And in addition to the graph here, I refer you to figure 8 of BRG2 at page 62, where it's a comparison of the Charlie Hotel to the rest of the Colombian market, and you can see market exceeding profit margins, a history of that by the Royal Property Group. And if you look at the individual drivers, it's actually not that hard when it comes to a real estate investment. There aren't as many drivers as a mining or an oil and gas or a resource context as there are when you're talking about real estate, property. You're talking about property and the costs in this case, for example, CBRE in their export report actually say, according to claimant's model, construction costs are pretty much aligned to our professional opinion. Costs, not an issue. One of the key driver, CBRE accepts, is pretty much aligned with their professional opinion. And then we deal with the other side, revenues. And those are based, in this case, on the contemporaneous business models of the claimants. And as we know, that's some of the best evidence you can have because it's used for real life purposes. The CC Devas case makes that clear. And in this case, they were used for many purposes, including the fiduciary, setting the equilibrium point, is based on these business models. Sellers, in many instances of the new projects, sellers were accepting payment as the final apartments because based on the models. These business models were actually used to transact. Claimants are owed, in addition to that, what that DCF model produces, as verified, by the way, by actual market studies by JLL, pre-award interest. And we would submit, as the Eco Oro found, that the U.S. Treasury rate is not a commercially reasonable rate of interest. But in any event, for an unlawful expropriation, the correct measure should be putting the claimants back in the position that they would have been in but for the unlawful actions, and that includes in the assessment of interest. But BRG has been very conservative, I would suggest, by using not even a rate that puts you back in the position you would have been in but for the unlawful actions, but they use a commercially reasonable rate of 5.03. That would be analogous to, for example, a prime or prime plus 1 type rate. And they took this conservative approach to reach the damages that you see on this slide. And again, as I said, all of this will be articulated in much more detail when you hear from BRG. I'll turn the floor over now to my colleague who's going to address you on jurisdiction before I conclude. I think we probably have about 15 minutes left in our presentation. I'm not sure where we're at exactly on time, but it's probably an appropriate time to do a time check.
17 minutes, according to my...
Okay, so we should be fine. Thank you.
Good afternoon, Mr. President, members of the Tribunal. Thank you for the opportunity to address you today on behalf of claimants. I will be providing the Tribunal with an overview as to the basis for its jurisdiction to decide the present dispute. Thank you. To decide the present dispute pursuant to the terms of Chapter 10 of the TPA and Article 25 of the ICSID Convention, namely because, first, the claimants are protected investors under the TPA and the ICSID Convention. Second, the claimants own a protected investment under the TPA and the ICSID Convention. And third, the claimant's claims in this arbitration directly relate to Colombia's unlawful measures. I will also be addressing jurisdictional objections that have been raised by Colombia with respect to these points before Mr. Malou concludes claimant's opening statement. Turning first to the ratione personae requirements under the TPA. Claimants accept that in order for an ICSID tribunal to exercise jurisdiction over a claimant, the ratione personae requirements in both the ICSID Convention and the TPA must be met. Under the TPA, pursuant to Article 10.16, an arbitration can be initiated by a claimant. Article 10.28, in turn, defines a claimant to be an investor of a party, and the TPA recognizes that investors can be natural persons with the nationality of a party, or alternatively enterprises, which are entities constituted under applicable law. Similarly, Article 25 of the ICSID Convention extends the Centre's jurisdiction to nationals of another contracting party that are natural or juridical persons. There are 9 claimants in this arbitration, 7 natural persons and 2 enterprises. Colombia, at paragraph 503 of its rejoinder, does not contest that the 7 natural person claimants and 1 of the enterprise claimants, JTE International Investments, can qualify as protected investors under the TPA. Moving then to the second jurisdictional point in dispute. Each of the claimants owns a protected investment under the TPA and the ICSID Convention. Article 10.28 of the TPA incorporates a broad definition for what constitutes an investment, to include every asset that an investor owns or controls, which has the characteristics of an investment. The TPA, thereafter, sets out non-cumulative and non-exhaustive examples of what such characteristics could include. Article 10.28 further provides the forms that an investment may take, including relevantly an enterprise, shares, equity participation, as well as management and revenue sharing contracts. The tribunals in Seoul and Korea and Avon and Costa Rica, interpreting a similar provision in the Chorus FTA and DR-CAFTA respectively, likewise have found that not all 3 characteristics must be present cumulatively for an asset to qualify as an investment, and none of them is indispensable. Claimants' investments in Colombia are comprised of a bundle of rights, including the shares owned by each of the investors in Newport, Luxay, and or Royal Realty. The chart on this slide sets out the equity participation of each of the investors in these enterprises. Respondent attempts to cast aspersions on whether these shares can qualify as an investment because the shares are subject to a pledge in some cases. However, it is uncontested that the claimants own these shares, and the TPA only requires ownership or control. The existence of a security interest through a pledge, for example, does not alter the share's ownership. Claimants' investments in Colombia also include management contracts that were in place between Royal Realty and Newport, as can be seen at C120, as well as Royal Realty and Luxay at C101. These management contracts entitled Royal Realty to payment of a management fee for operating the hotels in both developments. Royal Realty also had the prospect of many more management contracts for other projects that were in the pipeline. Mr. Seda further invested equity in enterprises through the investment vehicles he set up for the development projects, RDP Interparmas, RDP Cartagena, and Rev Marketing. Accordingly, it is clear that between their equity interests in Newport, Luxay, Royal Realty, and the development companies, as well as Royal Realty's management contract, the claimants own a broad range of investments, each of which display the characteristics of an investment. However, in its submissions, Colombia asked this tribunal to find that the ICSID Convention creates a separate jurisdictional hurdle that investors must discharge in order to gain access to ICSID arbitration. However, it is trite to say that the ICSID Convention does not include a definition for the term investment, or the so-called cumulative criteria that Colombia is attempting to read into the Convention. a number of arbitral tribunals agree that these criteria are of limited relevance to the ICSID Convention. For example, the tribunal in Aberclatin, Argentina at CL 139 held that the criteria should not serve to create a limit, which the Convention itself, nor the contracting parties to the specific BIT intended to create. But in any event, claimants meet each of the criteria that have been advanced by respondent. First, claimants have made a contribution and/or commitment of capital or other resources as protected investors. In this regard, it is important to note that tribunals have held that there is no minimum contribution that needs to be made in order for an investment to qualify as being protected. Likewise, the TPA expressly contemplates that contributions are not limited to capital or funds, and also extend to other resources, such as marketing and real estate development experience, and decision-making, management, and expertise. Here, each of the claimants have made capital contributions to Newport, Luxay, or Royal Realty, and evidence of those contributions in the form of wire transfers and receipts can be found at Exhibits C358 and C359. Mr. Seda has additionally contributed other resources in the form of know-how, brand value, and his expertise in the development of luxury real estate projects. Moving to the second characteristic advanced by Colombia, each of the claimants has also assumed risk in making their investment in Colombia. As Colombia accepts, at paragraph 262 of its counter memorial, a commitment of capital is a corollary to the assumption of a risk. Here, claimants have assumed risk by putting their invested capital on the line and holding a concomitant expectation of profit. Mr. Seda similarly has assumed significant risk by channeling his time and efforts into developing the underlying projects and in developing Royal Realty. Finally, Colombia raises an objection with respect to Mr. Haas's standing to appear as a claimant, because he has structured his investment in Luxay through a family trust. However, the record shows that Mr. Haas made his investment through Haystack Holdings LLC, which in turn was controlled by the family trust of which Mr. Haas and his wife are the sole settlers and sole beneficiaries, as can be seen as C222, and of which Mr. Haas holds full control. Mr. Haas is also the ultimate beneficial owner of the shares. He has standing to claim relief before this tribunal, pursuant to the principle in international law that grants standing and relief to the owner of beneficial interests. Moving to the final jurisdictional objection in dispute, the claims advanced in this arbitration by claimants are directly related to the measures that are in dispute. Article 10.1 of the TPA provides that Chapter 10 applies to measures that relate to investors and covered investments. Colombia attempts to rely upon this provision to contend that this tribunal does not have jurisdiction over those claimants who have not invested in the Meritage project. However, tribunals considering similar language have held that the phrase relating to does not denote a narrow jurisdictional threshold issue without any regard for the substantive treaty protections that are being invoked by an investor. Instead, all that is necessary is a relationship of apparent proximity between the challenged measure and the claimant or its investment. Any further analysis is more suitably reserved for a consideration of the merits of a claim. As Mr. Malou has already covered extensively in his submissions, the measures at issue in this arbitration severely affected not only the Meritage project, but also Luxay and Royal Realty's pipeline of development projects. The impact on these projects of the asset forfeiture proceedings amounts to much more than a relationship of apparent proximity. Indeed, as Mr. Malou outlined, there is direct causation, and accordingly, this objection should also be dismissed. I'll now turn the floor back to Mr. Malou to conclude for claimants.
I'll be very brief, members of the tribunal. I do want to say one word on moral damages, which, as you know, we are claiming in this case, and Article 31 of the Articles of State Responsibility contemplates allowing. And in the Lusitania case, they explained, the court did, mental suffering, injury to feelings, humiliation, shame, degradation, loss of social position, or injury to his credit or reputation, there can be no doubt and of all of these things in that case, and such compensation should be commensurate to the injury. And they explained that such damage is the case, even though it is rare, where moral damage is appropriate. But further, the last thing I want to end on, and you know our request for relief, but I do think this is a case.
May pose questions after having heard the respondent. We will now have our lunch break and resume at 2:10, please.